Also, with the public, we have passed out comment cards. These comments and questions will be provided to the advisory board members as well as the council members at their next meeting. We will not be having public invited to be heard tonight, just so we can facilitate and get through the information. So I'd like to go ahead and get started. I want to introduce Dale Rademacher, the Director of Public Works and Natural Resources, and he will be presenting the speakers as well.
Thank you, Kim. This is a little bit awkward. I'm normally facing the other direction when we're talking tonight. So as Kim said, I'm Dale Rademacher. I'm the Director of Public Works and Natural Resources for the City of Longmont. And tonight we're fortunate to have all of our speakers that came and made presentation to the Longmont City Council on November 15th. They have all agreed, very graciously, I would say, to come back and present to us. We also have an additional speaker tonight that I will introduce as well. So just real quickly I'll sort of go around the circle here, and I'll start out with Janice Wisman. Janice is the Environmental Conservation Program Manager for Boulder County Parks and Open Space. Janice is here again, board and commission members, to respond to questions. If you have questions with regard specifically to the policies of Boulder County Parks and Open Space. Sitting next to Janice is Tom Parco, who is the planning manager for Weld County. And as you know, Weld County has quite a lot of experience with oil and gas exploration in their particular county. And thank you, Tom, for coming as well. And awkwardly behind me, continuing around the circle, is Tisha Schuler. Tisha is the CEO and Executive Director of the Colorado Oil and Gas Association for the state of Colorado. Sitting next to Tisha is Debbie Baldwin in red, and Debbie is the Environmental Manager for the Colorado Oil and Gas Conservation Commission. Next to Debbie is Wes Wilson. Wes is a new speaker who has not previously presented to our group or our city. Wes Wilson is a retired environmental engineer from the Environmental Protection Agency with over 35 years of experience with the EPA. And in 2004, Wes was involved with evaluating some deficiencies with regards to a study that the EPA did on fracking. I think I got that close. And not to be left out, Brian Schumacher with our Department of Economic Development. Brian is a senior planner with our department and will be speaking to us with regards to the city's land use regulations with regards to oil and gas exploration. And then last is Mr. Phil Barber, and Phil is the special legal counsel for the city of Longmont, who advises us with regards to oil and gas issues, and it primarily works for our city attorney and provides that direction to him. So with that, I'm going to open up tonight's presentation, and our goal is to try to have this presentation as close as we can to the one that we presented to City Council on November 15th, but we are human, and I can guarantee I won't be verbatim with exactly what I said the last time, even though I did watch the video. So this evening's agenda. First thing we want to do is we want to give a presentation on the issues. Again, there's no action being taken tonight. Tonight is really information for board and commission members and to give you guys the opportunity to hear those presentations directly and to have the opportunity to ask questions directly of the presenters. We are focusing primarily on city-owned property out in Weld County, which is where the activity is, if you will, with regards to oil and gas exploration. We are going to talk a little bit about the status of the existing mineral interests and leases on city properties, because they vary based on each of the properties that the city owns, whether it be owned, irrespective of the fund that may own the property. We're also going to talk a little bit about experiences with oil and gas operations on city properties. We're going to look at potentially, and from a conceptual level, the idea of consolidated drill locations, why that is good or bad, the pros and cons of that approach. We're also going to touch briefly on what's called a seismic survey. And board and commission members, I know you've had some prior information on this at your previous board meetings, but again, we're going to touch on that issue again because we did speak to it on November 15th. We're going to review the city's land use code and compare that to some other agencies. We're going to also have a presentation from the city's legal counsel, Mr. Barber, presentation from the Colorado Oil and Gas Conservation Commission, a presentation from the Oil and Gas Association, and to update this slide, we'll also have a presentation from Mr. Wes Wilson. So that is who we'll be hearing from tonight. And so just as an overview, the focus of our discussion tonight is what's known as the Greater Wattenberg Field, or the Wattenberg Oil Field. It is located in northeast Colorado. This particular slide sort of gives proximity of that oil field vis-a-vis Longmont, with Longmont being obviously right here. And you can see the expanse of the oil field to the east and north of us. There are somewhere over 17,000 producing wells in this particular field. It produces several trillion cubic feet of natural gas, as well as several million barrels of oil. In case some of you hadn't seen the article, there was an article recently in the Denver Post, I think it was on November 14th, where there was an estimation of potential reserves in this particular field on the magnitude of about 1.5 billion barrels of oil that could be recoverable from the field. And so I want to spend just a little bit of time talking about the city's property that the city owns out in Weld County. And I hope you all can see this map. I'm just going to go sort of briefly through it and what the different colors mean. And this is a map that shows property ownership by fund, okay? The city has any number of different funds that it operates under. So the properties on here that are shown in green are those funds, or those properties that have been acquired with the city's open space funds. The properties that are shown in blue, which are predominantly around Union Reservoir, are those properties that have been purchased by the city's Water Utility Enterprise Fund for the purpose of the future expansion of Union Reservoir. The property that's shown in purple here is along Spring Gulch number 2, and that was acquired with the Storm Drainage Fund in order to acquire the property that would be inundated in the event of a flood. And that property was acquired concurrent when the city acquired the larger Adrian property a couple of years ago. The property in what I'll call the lighter brown in these areas are owned by both the Park Fund, in the case of Sandstone Ranch, as well as the city's general fund. This particular property here is known as the High Plains Preserve. Some of us that have been here a while also know it as the former city landfill site. So those are sort of a rundown of the variety of funds that the city has utilized over the years to acquire property in Weld County. Now I got to figure out how to go again. So the next map is again a colored map that is intended to now talk to us a little bit about the underlying mineral interest situation underneath these properties. Again, it's intended to demonstrate that it varies by property, that it is not a sort of a one-size-fit-all, and in fact, it is there's quite a bit of difference. And so the properties in green are predominantly these areas to the east of Union and to the west of Union, Sandstone Ranch and High Plains Preserve. Those are areas where the city is the mineral owner, and that there is an active or current lease of the mineral rights under those properties. Okay? So that's an important distinction to know. City is the mineral rights owner, and it has been leased. These leases were all entered into, by the way, prior to the city's acquisition of the property, with the possible exception of the High Plains Preserve where the city's landfill was. I do believe the city itself may have been the entity back in the 1970s that entered into the lease. And I don't know that for sure, but I do believe, because the city has owned that property longer than the others out in Weld County. The darker brown properties, this portion of the Adrian property and these properties to the north and this property to the south are properties where the city does own the mineral rights. However, they are not currently under lease. Okay? And that puts the city in a different position with regards to the situation on potential exploration of oil and gas. The properties here that are I'll call the light pink color. This is the Sherwood property, the Distal property, and the Boulder Creek Estates property. Those are properties that are under lease, so the mineral rights are leased. And again, were leased prior to the city ownership of the property, and the city is not the mineral owner, okay? In other words, the mineral rights have been severed from the property prior to the city taking acquisition of that particular land. And last, there's a couple properties in blue. This property immediately to the south of the reservoir, and some smaller properties on the west shore of the reservoir that we are still evaluating the status of those mineral rights and mineral leases. Okay? So the next slide I have is starting to deal a little bit with this issue of consolidated drill sites. Why are they in the interest of a operator, and why might they be in the interest of the surface owner, in that case, the city of Longmont? The top portion of this map, and again, this is conceptual. This isn't intended to be an exact thing, but it's looking at it conceptually, is that based on the current Oil and Gas Conservation Commission rules and regulations, an owner of a mineral right has the right to drill within certain parameters as approved and promulgated by the commission. And in that case, you can see that the wells are typically dispersed. So previously, if we were standing here 20 years ago, the norm at that time was to drill individual wells in what's called individual drill windows on the property. And the wells were dispersed, and so they weren't all in one location. So what you ended up with was a bit of a, you can call it a pin cushion or whatever, a series of wells all over the property. And so the idea behind a consolidated drill idea is shown here on the bottom, wherein you would work to essentially consolidate the wells down into a smaller footprint, thereby avoiding as many wells dispersed over the property. And so, why is that in the interest to an operator? Well, at some level, it's probably, consolidation of facilities into one site is probably more efficient. They don't have as many pipelines running to different well sites. They don't have as many pipelines running to tank batteries and so on and so forth. From a city ownership of the land, it would appear to be a benefit, if you will, could be that it is shrinking the footprint of disturbance on the city's property to a more manageable level. These particular areas, again, conceptually are about 2 to 3 acres in size. Just to give you perspective of what we're looking at. There could be upwards of 10, 15 wells on a consolidated site. I don't know if there's a maximum number per se, but I haven't, I'm not sure of that, but I do know that that's sort of the potential magnitude. To give an idea of what it looks like, this is what I'd consider to be a consolidated well site. It's located just due east of the city on Weld County Road 9. If any board members or members of the audience want to see it, you'd head out on 119 to I-25 and go north on Weld County Road 9.5, which is right there at the interchange, if you will. And it's, as you come up the hill, you'll see it. So this is showing the treaters and the separators on that particular site. And right across that driveway, if you will, is the tank battery. And I believe this site probably has somewhere around 10 wells, 8 to 10 wells on this particular consolidated site. It was constructed, I think, maybe 2 to 3 years ago. So that's just a brief overview from city staff with regards to the issue of consolidated drilling. some potential pro-cons on why it might be of interest to either an operator or a surface owner to explore the potential for entering into that type of an agreement. This next drawing is simply shows again the land that the city owns in Weld County north of Highway 119. And the reason we're showing that is that we've been approached by a firm known as Cougar Land Company, who is, we understand, working on behalf of Anadarko, an oil producing exploration company, for the purpose of doing seismic surveys of large areas in eastern Colorado. Very large areas, on the magnitude of hundreds of square miles of area. And they have approached the city of Longmont to inquire whether or not the city would be inclined and interested into entering into a permit or issuing a permit for the purpose of allowing seismic survey. And so when we said, what does that mean? City staff did take a road trip, I call it, went out into almost to the Pawnee Buttes. It's a beautiful area out there. It's on the sort of the grasslands of northeastern Weld County, and viewed what a seismic drill operation looks like. Seismic survey, not drill. And so what you're looking at here are what's called the vibe trucks. And what these vehicles do is they have a vibrating plate that's, I don't know, it's probably 10 feet by 6 feet in size. And they literally place that plate on the surface of the ground and induce vibration into the ground. And I'm not a geologist, and I know some of you are probably much sharper than me on that, but what I understand is that that vibration goes through the different soils and formations of rock and rebounds back and gives a picture, if you will, of what's underneath there. And so those signals are picked up by hydrophones over the surface of the ground that pick up those vibrations and relay that into a sort of a central truck that is collecting that information. And so there are questions with regards to how that would work with regards to that being conducted on city property, and again, whether or not that's in the interest of the city to do it or not to do it. When we were there, they explained to us that there are different approaches that can be taken with regards to gathering the information, things like limiting where the vibe trucks can operate. Controlling how the cables get laid out, because essentially cables get laid out on a grid format, both to pick up to receive the information. What's the other? There's another one at another angle. There's two grids of, the vibe truck. Excuse me, the vibe trucks go on one angle. You can tell I'm not a geologist, and the hydrophones are perpendicular to them, picking up the information. And so they can bring those cables in either by foot, or they can bring those cables in by using a Kubota small little Ranger vehicle that I think a lot of farmers would prefer, so as to prevent damage to their fields and to prevent damage to their soil. And so they're underway doing that. And Cougar Land, the company that has approached us, is doing an area that extends out east to just east of Platteville, back to the Boulder-Weld County line, Weld County Road 1, and then north and south from Highway 119 several miles to the north. So it's a large swath of this part of Weld County. But there is a much larger area that is actually having this survey conducted on, literally hundreds of square miles. So again, that is a potential issue that might be coming forward. I don't believe at this point we have received a permit, but I think we are looking at that, and that is an issue that will also, our intent is to have that come to the boards and commissions Staff will probably come forward with some recommended conditions to be considered. And, the obvious question, the first question is yes or no. Do you, for advisory boards, do you recommend that it's something in the interest of the city or not? And only if it is in the interest of the city, what conditions do you believe would be appropriate and necessary? So we're going to be talking with you about that in some of your upcoming meetings. So look forward to that. I think with that, I do just want to reiterate that the presentations that we're going to be doing and the order of them. Let me get that in front of me here. So Brian Schumacher will come up after me. And again, Brian is now going to talk a little bit about and give some information with regards to the city's current land use code as it pertains to conditional use site plans for development. Following Brian will be a presentation from our legal counsel, from Mr. Barber. And then we're going to have Wes Wilson come up and speak right after Mr. Barber does. He will then be followed by Debbie, who will speak from the commission's perspective. And then finally, we'll hear from Tisha Schuler from the Colorado Oil and Gas Association. Once that's done, then I think our facilitators are going to open it up for question and answer from our board and commission members. So that's it. And Brian, if you would like to come up.
Thanks, Dale. Again, I'm Brian Schumacher with the City Economic Development Department in Planning and Development Services. And I'm going to be fairly brief with regard to my remarks, just to kind of give you an overview with respect to the city's current regulations and process with respect to what an oil and gas drilling or production facility would have to go through the city's review process. For properties that are under city's jurisdiction, those that are annexed into the city, oil and gas facilities are required to go through what's referred to as a conditional use site plan review. So that involves a public hearing process. And the first step involved with that is a neighborhood meeting, and those are required before an application is submitted to get input from surrounding property owners and other interested parties. The next step after the neighborhood meeting would be for an applicant to make a formal submittal, and we would make a determination to make sure that the application is complete. And if it is complete, then we would distribute that application out to not only city staff, but also various referral agencies, surrounding property owners, as well as neighborhood groups and other interested parties that might be interested in the proposal. It will go through, typically it go through several reviews through the process, the staff level review. And what we do is we consolidate comments that we receive from the various city departments, as well as the referral agencies surrounding property owners and other interested parties, and consolidate those comments and submit those to the applicant for their review and response to those particular comments. Once those applications are revised and the plans are resubmitted, we go through a second review and to make sure that the issues that need to be addressed have been addressed adequately before that application is scheduled for review by our Planning and Zoning Commission. So once we get to a point of scheduling for review by the Planning and Zoning Commission, there is a public hearing scheduled. We send out notices at least 2 weeks in advance of the public hearing to all the surrounding property owners and other interested parties that have expressed interest in the application. The property or property locations are posted. There's notice provided in the Times Call. And then we'd have a hearing with the Planning and Zoning Commission. The Planning and Zoning Commission typically meets once a month, although on occasions when we've had extra items on the agenda, we've met 2 times per month, and typically the meetings are the 3rd Wednesday of each month. At that meeting, when the public hearing is held, there'll be a presentation by the applicant a presentation by staff. There'll be questions asked by the commission of the applicant and/or staff. And then at that point, the commission would open up the public hearing. And at the conclusion of the public hearing, then staff and/or the applicant will be likely asked to respond to questions that come up or issues that are addressed as part of the public hearing process. And then the commission would deliberate, and most times they make a decision the same evening as the public hearing. There are occasions when the commission requests additional information, and the application is postponed to a date certain. So typically that's the following meeting that's available for the commission. Once the commission gets to a point where they make a decision on the application, either in favor or in opposition to the application, there's a 7-day appeal period. So for example, if the application is approved, any interested party can appeal that decision up to City Council within that 7-day appeal period. And likewise, if the application were denied by the Planning and Zoning Commission, the applicant would have the opportunity to appeal that decision within that same time frame up to City Council. If the application is appealed, there's a 60-day window in which an appeal hearing is held by City Council to review the application. And that's also considered a public hearing by the City Council, and the City Council can take new testimony if they feel it's appropriate. Typically what happens is that the appellants and the applicant would have an opportunity to address the council, and the council can make a determination on whether or not they want to consider additional testimony as part of that appeal hearing. So just briefly, the city adopted our current oil and gas regulations in 2000. And to some extent, they were modeled after regulations that the city of Thornton had in place at the time. And since the regulations have been in place in 2000, we've only had one application that has gone through the conditional use site plan application process, and that was the application was submitted, I believe, in 2003. Went through the process, and that was on the Sandstone Ranch Park, south of if you know where the Visitor Center House is at the Sandstone Ranch. There's a well just south of there, down closer towards the river. It's referred to as the Evans 6 well. Another well, excuse me, was proposed, and that was referred to as the Evans 8 well, was proposed and approved as part of that conditional use site plan, but that was never drilled. So with respect to the standards that are currently in place regarding oil and gas facilities, the standards currently address things such as setbacks, both from structures as well as rights-of-way, production site containment, visual impact mitigation and aesthetics, access road design and maintenance, noise mitigation, floodplain compliance, oil and gas transport, air quality, wildlife mitigation, and signs and screening and landscaping. So those are the things that are addressed specifically in our oil and gas standards in our use regulations. Since this goes through a conditional use site plan process, there's also the standard conditional use criteria that apply to all conditional uses throughout the city. And those typically, just to paraphrase, they address compliance with the municipal code and the comprehensive plan, compatibility with surrounding properties, and mitigation of impacts. Since oil and gas production has been determined to be of state interest, local governments are somewhat limited with respect to what they can and cannot regulate. And our next speaker, Phil Barber, will address this in a bit more detail. As Dale mentioned, we're fortunate this evening to have a few speakers from Boulder County and Weld County here this evening to answer questions that the boards and commissions may have for them. Tom and Janice We're here on the meeting that the council had on November 15th. And I'm going to briefly go through and make a few remarks regarding some of the land use regulations that Boulder and Weld County have regarding their procedures and policies. And I'd appreciate if Tom and Janice would correct me if I stray off. So I'll just be very brief. As Dale mentioned, Weld County has extensive experience with respect to dealing with oil and gas exploration and development. The majority of the permits that are issued in unincorporated Weld County are in the agricultural zoning district, where oil and gas drilling or production facilities are used by right. In other zoning districts, oil and gas drilling or production facilities require either special use review or site plan review. But I believe, correct me if I'm wrong, Tom, but the vast majority of the permits are used by right in the agricultural zoning district. With regard to Boulder County, Janice had provided me with some information previously about this, but with respect to drilling on open space parcels, if there's an existing lease in effect, then drilling can occur, but the county works with the operator to minimize impacts through a surface use agreement, and that addresses various issues associated with potential use of the land, reclamation, and trying to site the drilling operations so it minimizes impacts and tries to address some of the goals and policies associated with the intent of the property as an open space parcel. If there's not a lease in effect, the county does not lease the open space for drilling. That's a pretty hard and fast rule, I believe, for Boulder County. There currently are approximately 112 producing wells on Boulder County open space. There's another 104 wells that are on private property that are covered by a county-held conservation easement. And then there's 10 more wells that exist on properties that the county either has an option to purchase or is negotiating for purchase of an open space interest. With regard to Boulder County's land use code, the land use code specifies that oil and gas production is a use by right in all zoning districts. Oil and gas production is subject to an administrative development plan review and approval, although it can be called up by the Boulder County Commissioners for review as part of a public hearing process. That's just a brief overview of kind of a comparison of what the city has with respect to Boulder County and Weld County. Very brief. We will be providing a bit more detailed comparison of our oil and gas regulations with other municipalities and counties at an upcoming meeting with City Council later this month. So that information will be available within the next week or so. So with that, that concludes my brief remarks, and I'll turn it over to Phil Barber to address some of the legal insights.
There's a saying about lawyers being two-handed lawyers because we say on the one hand this and on the other hand this. You're going to probably hear some of that tonight because even though there's been oil and gas exploration in Colorado for well over 100 years, a number of the very important issues that you all have on your minds, and I think the city has on its mind, are not settled. Some are not. Let me just start with just an overview of oil and gas regulation and basic legal concepts in Colorado. You have rights of ownership that can either be ownership where you own the surface and the minerals, where you just own the surface, where you just own the minerals, or where you maybe have a lease. Typically, the oil company that comes in and explores has a lease from the owner of the minerals. Dale did a nice job showing the different types of city ownership on this map where the city, in some cases, owns the surface and the minerals and are subject to lease. In other cases, the city owns the minerals with no lease. And in other cases, the city simply owns the surface and there's an oil and gas lease. Whenever you talk about an oil and gas lease, you're essentially talking about a contract, an agreement between parties. So to the extent that the city has entered into an oil and gas lease, or what we call a surface use agreement, which is another agreement that lays on top of the oil and gas lease that really talks about the specifics of what's going to happen on the surface and what kind of protections there are going to be. Those are contractual rights. If the contracts are entered into, then obviously the rights of the parties are set by those contracts. If the city owns lands that are not subject to lease, obviously they can choose to lease or not, and if they choose not to lease, then there generally will be no oil and gas exploration on those properties. If the city does choose to enter into certain leases, it can, as a landowner, require anything, essentially, that the other party will agree to. So there's a lot of negotiation that goes on whenever you enter into a lease. There's another concept in Colorado that applies to oil and gas law or oil and gas development that's important. I think it's called the doctrine of reasonable accommodation. The owner of the mineral rights, let's just say the city, has a duty, whether it's exploiting the rights itself or if it leases, and this is usually where it comes up, if it leases its rights, that lessee has a duty to accommodate the surface rights, and the surface owner has a duty to accommodate the mineral rights. And what does that mean? That just means on a case-by-case basis, people have to work together to figure out what their relationship is going to be beyond simply their ownership interests and beyond their leasehold interests. And in what happens in the world every day here along the Front Range is companies and landowners sit down, and some of you are undoubtedly familiar with this process, and you sit down and you try to resolve what's going to happen on your property that's either subject to a lease, or if you want to have a lease, what's going to be in the lease. So there's a lot of negotiation that can go on where the city has either a surface or a mineral right. And that's one avenue that I know the city is looking at in terms of trying to deal with some of the land use questions that have arisen. So you sort of go to the next level of rights that are, or laws or regulations that affect oil and gas development. Let's say you have a lease. Let's say you own the property that is subject to the lease. An example we use out here by the reservoir. Let's say there's an oil company that wants to drill a well and has a lease. So it has a vested interest that it can drill a well if it has the appropriate permits. At a statewide level, before any well can be drilled, and we call them operators, the oil and gas company has to go to the Oil and Gas Conservation Commission and get a permit. The commission will issue a permit, sometimes with conditions, sometimes without conditions, and the permit will essentially tell that oil company where it can drill its well. In addition to the permit, there's a whole host of regulations that the Oil and Gas Commission has adopted, and I expect that Deb will talk about those, that go well beyond where a well can be placed. They go into health and safety concerns. They go into noise control. They go into visual impairment and ways to control degradation of the visual environment. So you've got the commission, the Oil and Gas Commission in Denver, which regulates the drilling and operation of wells. In general, if the commission has a rule or has issued a permit, there is not a lot that a city or a county or a municipality can do to regulate those areas where the commission has the jurisdiction to regulate. There are other areas, though, that are areas where it's either not been regulated by the commission or where there may be some aspects of the activity that have not been regulated by the commission. And in those cases, there are 2 or 3 lawsuits that have been decided by the Colorado courts that say the local community continues to have rights to regulate in those areas. So there's sort of a tension between what a city or a county can do and what it can't do based on what the Oil and Gas Commission has said or hasn't said. You know, some of the things that it's pretty clear that a municipality or a county cannot do. A municipality cannot prohibit drilling. It can impose regulations that deal with some aspects of the operation of wells, but if an oil company has a permit from the Oil and Gas Commission, then in general, the oil and gas company will have the right to drill. So there are opportunities at the Oil and Gas Commission when somebody submits a request for a permit for people to object to that permit. And objections can be lodged based on health and safety issues, based on ownership issues, based upon setback issues, based upon noise, based upon a lot of different things. So I guess I mentioned that because your city has what we call a local government designee. And the local government designee is supposed to receive a notice anytime an oil or gas company desires to drill within your jurisdiction. And the oil and gas, or the designee, the city, affected parties, landowners, adjacent landowners, can actually go to the commission and object to the permit, ask for conditions of approval to be placed upon the permit. And so I raise that because many times when people want to object to an oil and gas well, the horse is already out of the barn. The permit's been issued, there are no conditions on the permit, and so I just think that you need to keep that in mind as to what you want to do if you want to be proactive in this process. One of the topics that has been very hotly debated, I was at the last meeting, is the issue of fracking. And I'm guessing that Deb will also address that. But just this last Monday, the Oil and Gas Commission held a hearing on what they call a rulemaking procedure. And the rulemaking procedure dealt with fracking, but in a fairly limited way. It just dealt with the question of what must be disclosed to the public as to the constituent chemicals or compounds that are used during fracking. And when must those be disclosed, and how must those be disclosed? There's been no final ruling from the commission yet, but that issue of disclosure of what you're entitled to know about those chemicals is before the commission right now. I've been asked, well, what can the city do? And really it's sort of very much a line-by-line issue. You look at what the oil and gas, first of all, you look at what the lease says if you're a landowner, if the city owns that property, or what the surface use agreement says if the city is the surface owner. And that will govern the relationship between the parties, because parties can agree to things as long as they're not illegal, that may be greater than what the commission requires or less than what the commission requires. So you look at those documents, and if there's nothing in the documents, the lease or the surface use agreement, then from a regulatory standpoint, where the city perhaps doesn't own the property but just wants to regulate the conduct on property in its jurisdiction, you look at what the commission has done, you look at the city's rule, and you see if the city's rule conflicts with or doesn't conflict with the commission's rule. And if the city, a city, wants to impose greater regulation, then you have to just look at it on a case-by-case basis to see if that regulation is going to be appropriate in light of what the Oil and Gas Conservation Commission has said. So it feels like a beginning course in oil and gas law, and I'm surprised that you all are still awake, but I'll be here, and I'll be happy to answer more questions, but I think the main points I'd like you to take out of this is that the city stands in a different place where it is a surface or a mineral owner. It stands in a very different place if it's a surface or mineral owner and the property is not leased. And then it has a lot of rules that govern what the city can do based upon what the Oil and Gas Conservation Commission has said, where the city is simply acting in its municipal capacity and not as a landowner. So I'll be here for more questions, but that's sort of the lay of the land of oil and gas law, if, hope it's helpful. All right, thank you.
I wonder if I could do it sitting down so I could face everybody. Can you keep me up, please? That's where my camera will get you. Oh, sure. Let me say at the outset, I'm a right-handed expert. And it's good to follow Mr. Barber, because I'm going to give you citizens some education about it's not so limited as Mr. Barber would just imply with respect to your community rights. First, let's take a look at what's coming. We got to understand that the current drilling technology is not your grandfather's well. To drill one of these deep horizontal wells with slick water fracking is going to take 1,200 tractor and trailers, 5 million gallons per frac, up to 72 acre-feet once you add the 10 or 18 fracs per well. You consolidate them, and you have a large industrial activity at your doorstep. Oh, I have a clicker. What's happened before was the industry was after what's it called, conventional traps underground. They were looking for a location previously, in 50, 60 years ago, where oil and gas was trapped underground, as in the J sands, D sands here in the Dakota sands out in Weld County. And so they were looking at fields where often it had gas, water, and brine. Now, if they were just off that, they had a dry well. But once they were in the field and they started producing brine water, they re-injected it back to the same location. It was in their economic interest, a closed loop, if you will. If you look at this, the bottom part of this slide, what the industry is now after is oil and gas where it formed. Any place that was under the sea in the past is now a target for this industry. So they're going after the hydrocarbons in the rock, and they have, that hydrocarbon hasn't left that rock. What that means is there's very few dry wells. They're going after this mother lode, and currently they're after the Niobrara shale, which they're able to use this technology of horizontal drilling and fracking to obtain oil. This is the footprint of the Niobrara shale here on the Front Range. You'll notice the western boundary is just about right at the city of Longmont. This western boundary of this formation comes very near where we're standing today. I don't know how far west it'll go. But it is certainly turned into a rush by this industry. We're hearing from insiders that although there's 70 rigs in the entire state, this year, there may be as many as 200 by this time next year. You heard one speaker talk about 1.5 billion barrels of oil potential in this field. It may be quite higher than that. In fact, there's the potential to produce $1 billion of oil for each section of land that they lease for this purpose. I'm going to talk about some of the myths the industry would desire you accept, and try to uncover a little deeper into those myths. One is that this is a 60-year-old technology that's safe and proven. It's simply not true. What we're looking at with this combination of drilling underground and horizontal drilling with high-volume slickwater fracking is only a 5 or 6-year-old technology, and its safety record, the jury's still out. Now, the jury might well be out for things we know about the other type of drilling. We have contamination in Weld County. We've had thousands of accidents in that county. Denver Post reported last year there were 1,000 spills in a 30-month period. In other words, this business averages a spill a day. And by spills, we're talking about those over 5 barrels. Under that isn't even reported to the state. And certainly the spills of these undiluted fluids. Mr. Barber mentioned the Oil and Gas Commission's hearing this Monday on whether or not we as citizens get to even know what these chemicals are. Right now, we don't know. But even when we do know, what we will know is that they're endocrine disruptors, carcinogenic, they're nerve agents, and certainly the undiluted concentrations of these as they're shipped around in your community, that presents a significant risk. Once they come to the well site, they are mixed. Unfortunately, they may not be mixed to the point of dilution that prevents them from being toxic, because many of these chemicals are toxic at the parts per billion level. Consider benzene, for example, one of the common things in these petroleum distillates, in fact, in the gas itself, is toxic at just 5 parts per billion in drinking water. So we're looking at very dilute concentrations that can still be harmful if there's a pathway to us or to the wildlife. Leaking pits. Now, I would guess that leaking pits should be a thing of your past. Since we're in a non-attainment area, largely the state has organized this industry not to allow so many open pits anymore. But you need to make sure of that. I think some 75% of the new wells are being drilled without pits. That is, the fracking fluid comes back to the surface and put in a closed loop system. That's not certain. So you need to check whether that will occur if should drilling occur in the community. EPA is about to close this particular loophole too. EPA has a national rule out that would eventually block these open pits. That's where we have a lot of exposure, because the fracking fluid comes back not just with the stuff we don't know now what goes down, but even when we know what goes down, we're not going to know what comes back. Yes, that's right. The Colorado Oil and Gas Commission is considering a rule to tell us what's in the fracking fluids when it goes down, but they're not going to tell us what comes back. The very thing that could harm us, depending on what happened to those fluids. And that's important because the science tells us that what can come back can be different and even more toxic than what went down, particularly with respect to metals, radionuclides, and even the potential for creating long-chain organic molecules underground as a result of these heat and pressure. Production flowback fluid is a big, important issue. And I want to point out to you in very strong terms that the Department of Energy's National Committee, when it reported last month, gave a strong recommendation to counties and cities. And it encouraged them to manifest these wastes to make sure when they come back to the production pit or to the production tanks, that they end up where they're supposed to be and not somewhere else. That's not now occurring by the state, that manifesting of the waste. What the industry is generally doing is taking these wastes and re-inject them deeper underground into different formations in what's known as Class 2 wells. Here's the part of the science we don't know. And let me just say as an outset here, Monday at the Oil and Gas Commission hearing, we heard from a Mr. Howe from Halliburton, and that Halliburton engineer was presenting to the State Commission that he had some 5 studies to prove hydraulic fracking was safe. Upon detailed questioning by Commissioner Richard Allward, Mr. Allward was pointing out that those weren't scientific studies. They were surveys of various state organizations, but they weren't conducted in a rigorous scientific manner, what we call first principle science, looking at whether or not there's these multiple pathways underground and how contamination a pathway may occur. So that's what I call the question of good wells going bad. EPA has a national study now, it won't be available on this issue until 2014, but the question comes up whether the geologic separation between where the fracking occurs and the surface is sufficient not to allow the gas itself to move upward. Colorado is familiar with a case where this happened. In the case of Petroglyph, a company drilling in coal bed methane in a place called River Ridge Ranch Estates near Levita, Colorado. In fact, it is thought that the inadequate geologic separation between the coal bed methane gas and the surface, or rather the uppermost aquifer, was the pathway that caused methane to contaminate some 30 homes there. Those homes, 2 of them had a well pit blow up. Eventually, the industry reaches a financial settlement with these homeowners. Now, the Oil and Gas Commission, Dave Nestlin, has just issued an order to that company to plug those wells and walk away from the contamination. The homeowners are paid off, but the groundwater there remains polluted. Now, the part of the systemic risk where VOCs and hazardous air pollutants come back to the pit is what I consider one of the more significant pathways. You know, here in Colorado, the industry takes great advantage of our solar conditions. And a lot of the produced water that comes back is evaporated in these open pits. If that's the case, that's a significant hazardous air pathway right to you and I, or anybody nearby. The final point I have on this slide is quite an unknown. We don't know if these hazardous air pollutants or VOCs might attach themselves to particulate and came right back into the ecosystem. It's even a myth that the natural gas that's produced off of this industry itself is clean. Now, we know, of course, that when you burn natural gas, it doesn't have the SOx or the NOx or the particulate matter. But as research from researchers in Cornell University have pointed out, they simply calculated up all the leaks from the industry, and because methane is so much more effective at trapping heat than CO2, concluded on balance, natural gas actually makes us equal to or worse off than coal production for electric power when it comes to climate change. So we're not even getting the climate benefit that we thought we were getting. The industry would like us to believe that fluid migration is rare, that very little of what goes down and what is fracked can risk contamination added into the surface, particularly here, where some of your neighbors around town will be dependent on the Laramie Fox Hills aquifer for their drinking water. Canadian researchers looked at this, they looked at some 250,000 wells across Canada, and they found fully 12% of those had some gas flow at the surface. EPA has just found out in Pavilion, Wyoming, after it had to drill engineered monitoring wells, that operations there by Encana, including fracking, possibly have contributed to the groundwater contamination. The groundwater contamination is serious there. It's toluene, benzene, methane, 2-butyl ethanol, a product used in fracking fluids. And indeed, the administrator of EPA has now come out and said that the most likely pathway causing that contamination was a result of fracking by Encana in that field. Right here at home, let's go a little closer to home, one of the COGC reports that Debbie Baldwin suggested you go to on the library on COGC is a baseline report trying to look at some of the groundwater conditions in Weld County. Unfortunately, they only looked at 9 wells, but what struck me was that fully 36% of the gas wells had some kind of gas flow at the surface casing where there shouldn't be flow. Even Oil and Gas Commission's document attempting to correct this popular movie Gasland, which I'm in, the Oil and Gas Commission's document called Correcting Gasland confirms 2 of the key scenes in that movie. It confirms that the property of Miss Amy Ellsworth was indeed contaminated by the industry since it had thermogenic gas. Unfortunately, Miss Ellsworth reached a typical agreement with the industry, requiring her non-disclosure once the financial settlement was arranged. The other scene was on Lisa Bracken's property on West Divide Creek in Garfield County. And in this document that the Oil and Gas Commission points out, they say, well, that location may have had biogenic gas coming from the swamp, but just 1,500 feet away, they point out, thermogenic gas is coming to the surface as a result also of Encana's drilling. The cause there was more or less determined to be a leaking well by that operator. We get to this issue that the state says it has this voluminous data to support its claim that groundwater hasn't been contaminated. My problem with that as a scientist is we're not dealing with engineered monitoring wells where we know where the sample fluid is being drawn from. Instead, we're reduced to looking at baseline conditions in domestic wells, and only those wells where the homeowner volunteers to have it done. The big problem is the state often doesn't determine the cause. In the case I just mentioned of Amy Ellsworth well in Weld County becoming contaminated with thermogenic gas, the state of Colorado never determined the cause of that. We don't know. And what happens in this industry, what's been going on for 100 years, if the individual landowner can prove their well has been contaminated by the industry, if that's possible through a demonstration of proof, often the resolution is a financial payment and silence, a non-disclosure agreement, presenting the rest of us with no information on that case. Finally, let me get to my last 2 points with respect to what citizens can do. It's simply a myth that Colorado cities and towns are preempted by the state from regulating drilling. I have an excellent legal paper here written by David Baumgartner and Jeffrey Robbins. David Baumgartner is the current county attorney for Gunnison County, who's in quite a squabble with the state over whether the state preempts that county from making more stringent regulations. They put together quite a clear and cogent legal brief that the counties didn't give up their authority when the state legislature said the State Oil and Gas Commission was going to conduct drilling. And the case law seems to hinge on this if it's not materially different and can be harmonized with the state rules. So, for example, it certainly seems clear to me that a county or this city, under its home rule authority, could make a larger setback. You know, my colleagues and I just last week were briefing some gentlemen from Jordan, the nation of Jordan, who come over here and they're considering hydraulic fracking. They were appalled when we said in our rural communities a well can be 150 feet from a home, just 350 feet if you're in a community setting. It's clear to me that counties can have the authority to increase that distance, and that, in fact, what Gunnison County is doing. You could obligate a cleanup condition. There's no reason to go hat in hand and leave this industry walk away from its mess. Yes, you're going to hear tonight from Debbie Baldwin about how many rules the state has. I want you to think of them as the red light. The state has put up the red light. You're going to hear from Tisha Schuler that the industry stops at the red light. As you listen to them, I want you to think how many people didn't stop. The issue isn't safety because everybody stops at the red light. The issue is the transgressions, the number of spills. The number of notice of violations in Weld County exceeds 1,000. Unfortunately, the database doesn't carry more than 1,000, so we can only look at those 1,000 events. You can certainly require closed-loop systems. I think that's coming anyway if EPA does its rule, but we never know since the rule's not final. I think the city could demand benign, clean fluids be used. You know, Halliburton's going around this nation and drinking fracking fluid. It calls its Queen Sweep program. I say, fine, if they can drink it, they can use it, and you can say that. In fact, that happened here in Colorado. Grand Junction and Palisade made an arrangement with their operator in their watershed that only benign fluids would be used for fracking. And you can certainly obligate groundwater monitoring. Don't be dependent upon whether we know this industry is doing well by a few domestic wells scattered here and there. When you look at that EPA Pavilion case in Wyoming, the only reason that the EPA was able to unravel that science, it's had to drill its own monitoring wells, where the geological engineer knows where the formation that they're pulling their sample is, where it's screened and controlling everything aspect of that well so that there's no inappropriate maintenance done by the homeowner to screw up the scientific results. And finally, we get to the last point. It's simply a myth that cities cannot stop drilling. I am shocked by Mr. Barber's reading of the law. There's certainly no doubt that contract law exists, but more importantly, home rule exists. When this state legislature was being set up under its territorial law, there was great reticence by the cities of Denver and Central City to send its power to the state legislature. It held back. In our Constitution, there is the rights of the home rule city. You don't have to accept this any more than you would have a pig farm downtown. You have the right under a home rule to set the industrial conditions within your community. On the second paragraph here, I quote a well-known Supreme Court case. You know, contracts aren't absolute. How could we have a government if I could do anything on my property to the detriment of you? That's what we mean by government. Contracts are restricted by the citizens' sovereignty. Most importantly, you don't have to be the first to do this. Pittsburgh did this last fall, and it had, much like Longmont, already existing land with existing leases. It voted eventually by its city council to simply ban the drilling for oil and gas, natural resources within the city limits. We've got 140 communities that have done that around New York and Pennsylvania. And a big activity for the city of New York was that it itself got the state legislature to ban all drilling within its entire watershed. A similar effort needs to take place here for Denver and Aurora. So I leave you with those things to contemplate about your authority to both make it more stringent, if that's your direction, or to preempt it, if that's your citizens' desire. And as you listen to the next two speakers, don't think just that the traffic lights are good. Ask when the industry didn't stop. And I'll be glad to take a few more examples of when the industry didn't stop at these rules here in Weld County. Thank you.
All right, good evening. I'm Debbie Baldwin. I'm the environmental manager for the Oil and Gas Conservation Commission. And I have made the presentation on November 15th. And so I'm going to try and keep it a little shorter today because a lot of you were at that meeting, and just make sure that there's plenty of time for questions. So let's see. So an important website for you folks to get to know is the Oil and Gas Conservation Commission's website that does have a great deal of information on it. And Wes has correctly identified a lot of the information that is available on that website. So, and in fact, a couple of the folks here tonight have, have already done some mining of our information and had some questions about reports that they found on our website. So the mission of the, let me go back for just a minute, yeah, okay. The mission of the Oil and Gas Conservation Commission is twofold. We have a dual role, fostering the development of oil and gas resource and making sure that it's a balanced development and the production and the use of that is appropriate, but we also have to balance that with protecting public health, safety, and welfare. So it is a different role than a health department would have. We have a balancing role. There are about over 46,000 active wells in the state of Colorado, and nearly at least 90% of those wells have been hydraulically fracked and have been fracked maybe not just once but multiple times. So it is an activity that has taken place for years. The technology has changed and improved, but nonetheless it has been an ongoing procedure, and there are 46,000 wells in the state. There are about 17,000 active wells in Weld County. So the Oil and Gas Conservation Commission does issue the permits. Operators have to apply for a permit. They submit an application for a permit to drill. And this map shows the state of Colorado and where those permits have been issued recently. And so this large blob of dots up here represents the greater Wattenberg field, so Weld County. The area over here in the western part of the state is the Piceance Basin. Some of you have maybe heard of that. Garfield County, Rio Blanco County, another large gas-producing basin. The southwestern part of the state down here in La Plata and Archuleta County is a primarily a coal bed methane producing basin. It's the largest in the world. This is just the northern part of that San Juan Basin. It extends down into New Mexico, but about 30% of the gas produced in the state comes from about 2,500 wells down in this part of the state. There are also conventional wells in this part of the state, and also a very large carbon dioxide field. This area over here, down near Trinidad, Colorado, is the Raton Basin, and that's another coal bed methane producing basin where the gas is actually coming out of the coal seams. And probably a lot of you are familiar with gassy mines. Coal mines will have methane gas in them, and so in these areas they're actually producing the methane gas that's in the coal seams. There are other fields, other places in the state. This is a pie diagram that shows the number of permits that have been issued, and it breaks down by county. So we had a map view, but now this is the actual numbers. So when this slide was produced in November, early November, there were about 2,000 permits had been issued in Weld County. That's about 50% of the well permits that were issued by the Oil and Gas Conservation Commission. About 28% in Garfield County, so that's another large active area in the state. And then, permits in other parts of the state also. This slide is a fairly interesting slide, or at least I think it's interesting. So what it shows, it goes back to year 2000, and so what it's showing is the total number of APD stands for application for permit to drill. So it shows the total number of permits that were issued and how many of those permits were issued for wells that were going to be directionally drilled. So not just a vertical borehole, but actually drilled and then deviated underground so that the bottom hole location was different than the surface hole location. And then, whoops, wait a minute. And then also showing in green, so the directional wells are in the purple color or the magenta color, and then in green are the number of wells that are being drilled, or permits for wells being drilled directionally. So that is a new technology, and it's something that has been a huge improvement in drilling operations, that there's actually a motor on the top of the drill bit, and with all the electronic controls that now can be used, the bit can actually be driven to the bottom hole location. So that's enabled operators to drill a vertical well down to the target formation. So around here, Niobrara formation may be down at about 7,000 feet. Drill down to that and then turn the well bore horizontally and then kick out and drill up to a mile, sometimes even a little farther away from the vertical hole. And so what we're seeing is, Dale was talking about these consolidated well sites. Well, it really is the advent of the ability to drill directionally or horizontally that is enabling operators to consolidate their operations and drill multiple wells from one pad. It has a good effect, and it can also have bad effects. The good effect is that, as I think Dale or somebody was saying, that you consolidate the roads, the pipelines, thanks, appreciate it, thank you. The roads, the pipelines, the production facilities into one area. The waste management facilities are consolidated into one area. So that is better overall for everyone. But the bad news is that you consolidate everything in one area, and so for the people that are located in closer proximity to those multi-well pads, the inconvenience and the nuisance of having those operations take place is definitely increased. So we try and work with the people that are going to be affected by that longer-term drilling and see what can be done to mitigate the potential impacts from that long-term or the drilling that takes place over a longer period of time. So the commission has about 70 employees. We're a division of the Department of Natural Resources. About half the staff operates in the Denver office. Out of the Denver office, about half the staff operates in regional offices or out of their home offices. So I'm going to talk a little bit about the three technical groups, the engineering, environmental, and inspection group, but we have a lot of other groups. We also have our commission, our Board of Commissioners, 9 governor-appointed commissioners. We've heard we had a rule, we're in the process of a rulemaking hearing right now. 2 of the commissioners are the executive director of the Department of Public Health and the executive director of the Department of Natural Resources. And then the other 7 members are divided along political lines and their experience with oil and gas or royalty owners or the environmental group. So it's a fairly large, a broad spectrum of people represented on the Oil and Gas Conservation Commission. So there are engineering staff, again, that's just, all these maps are available on our website. If you had questions about a well being drilled in your area and had an engineering question, you can figure out by looking at the map who would be the engineer that you might want to talk to. They are all professional or engineers in training. They have PEs, or at least working towards PEs, and their main responsibilities are to review the applications for permits to drill, and very importantly, to review the design of the casing and the cementing of that pipe that goes into the ground, because what that ensures is that there will be isolation between the hydrocarbon-bearing formations, because that's what these wells are being drilled for. They're being drilled to produce oil and gas, and the groundwater resources that are overlying it that are used by people. They're also, they also look at the completion rules, or the completion reports, the cement bond logs to verify where the cement seals are placed. One important part is to ensure that when a well no longer is needed, that it's properly plugged and abandoned. So they review the plugging and abandoning operations. We also have funds for plugging and abandoning ourselves wells that we call orphaned, that there's been well over 100 years, 150 years of oil and gas development in the state. Practices were different a long time ago, and so periodically people do find wells that have not been properly plugged and abandoned, and we have the resources and the technical expertise to go in and enter those wells and get them, make sure they are properly plugged and abandoned. We also implement the underground injection control program for the Class 2 injection wells, and that's a responsibility that's delegated to the Oil and Gas Conservation Commission from the EPA, and those are the Class 2 wells that you can be used for disposal of fluids, but also for enhanced recovery. And I think Wes mentioned enhanced recovery, which just enables more of the resource to be produced. We have field inspection staff. There are 15 field inspectors, actually 14 field inspectors and a manager. They're scattered around the state. They all work out of their own offices. Just recently, we hired 2 new inspectors that are also working up in the northeastern part of the state, so we have a full complement of inspectors now. Last year, they conducted over 17,000 inspections. They went to 17,000 different wells and looked at them. They do inspections during drilling, during completion activities, during plugging and abandoning, but they also do routine inspections. But one of their primary functions is complaint response, that they're the people that are the first boots on the ground, and they're the people that if you had a complaint about a noise or odors or weeds or a spill or a release, actually you should call the operator first. If there's a spill or release, call the field inspector, and they're the people that'll go out immediately and have a look and see what they can do and see if the situation can be modified or mitigated. They also we have reclamation requirements, so that after a well's drilled, the well pad has to be shrunk. While the drilling and completion activities are going on, there's a lot of activity and it takes a large area, but once the wells are drilled, the pads can be shrunk. And so if you drive around in Weld County, what you'll see is really a well with farming right up to to the little fence that's around the well in many situations. The environmental staff, that's the staff that I manage. There are 14 environmental specialists, or geologists, hydrogeologists, or geochemists. We have a group here, and this is a group that is an important group for the local governments to get to know these folks, what we call the oil and gas location assessment people. So not only do operators have to permit the wells, but they also have to fill out a form that describes what the surface disturbance of the well site itself is going to be. And on that, they'll tell you how many tanks there are going to be, how many wells are going to be drilled. So how close are they to surface water, how close are they to houses. And it's these folks that review all of those, the surface disturbance, and will set the conditions of approval for mitigating impacts to this, that would occur from surface activities. Let's see. So the environmental group, what do? So the groundwater standards and classifications are set by the Colorado Department of Public Health and the Environment, the Water Quality Control Commission. And we implement the standards that are set by the Water Quality Control Commission. It's another governor-appointed commission for this oil and gas industry. So we ensure that operations are in compliance with or will achieve those groundwater standards and classifications. We oversee and permit the waste management facilities. Now, not all the wastes that are generated by oil and gas are regulated by us. So they're just routine trash. Those kinds of materials are solid waste. There are other materials that are solid waste. The Oil and Gas Conservation Commission regulates what are called exploration and production waste. It's the waste that comes from the drilling and completion and the ongoing production of the wells. Wes is right, spills and releases absolutely do occur. It's an unfortunate situation. We try and minimize those. This year, I think we had about 500 spills and releases. That's not good. We can all do better than that. But when you consider that there are 46,000 active oil and gas wells in the state, not that 500 is insignificant, but it is a relatively small percentage per well for, just to put it in some context. So when those spills and releases occur, they have to be mitigated, they have to be remediated. We respond to complaints alleging impacts to public health, safety, and welfare. Primarily in the past, we've been focused on water and soil complaints, although we do get noise and odor complaints also. We've conducted studies to collect baseline or current conditions from groundwater wells. I personally think that collecting samples from people's water wells is a good thing, not a bad thing, and that it's a way to see what is the water quality that people are getting, and we can use that to determine whether or not an impact has occurred. Let's see. So, where do you find? We have the Oil and Gas Conservation Commission does have rules, and we have if you go on our website, you can see the rules. They're here under rules. We have a large body of rules. The rules that I'm talking about right now are going to be the 900 series rules, the exploration and production waste management rules, but there are rules related to how wells are drilled and how they're completed and how the wells maintain isolation to ensure that fluids don't mix in the wellbore, that the wells don't act as conduits for contamination. Our 900 series rules, we do have rules on pits because pits still are used in some areas. It's an efficient way to manage large quantities of fluids. Again, the industry is working very hard away from the use of pits. More and more operators use closed-loop drilling. Almost, I think, over 90% of the wells, maybe in Weld County, are drilled using what's called a closed-loop system, so there aren't pits. There are other places where pits still are used, and if they're properly constructed and maintained, they can be used safely. Spills and releases, operators, we have rules that say you have to report the spills, you have to clean the spills up, you have to contain the spills, you have to notify the landowner. We have rules for managing exploration production waste. We have site cleanup concentrations, the cleanup concentrations that we use. So if, if oil and gas or oil is spilled, it has to be cleaned up. The standards that we are actually derived from the Health Department's solid waste group. They're the most conservative numbers that any industry is held to are the numbers that we have selected for ensuring that spills and releases are cleaned up, to ensure that any future land use can occur. What happens to the E&P waste? Although you hear lots about the fracking fluid and completion fluids, there are other wastes that are generated. There are drilling fluids, so the fluids that are being used when the wells are being drilled, the fluids that are used for completing the wells, but actually the produced water over the lifetime of a well. So those operations, the drilling and the completion, take place over maybe a week, maybe a 2-week period. But eventually the well goes on production, and if the well produces water, not all oil and gas wells produce water, some produce a lot, some produce a little, but regardless, there's typically some water produced, and so over the lifetime of a well, that produced water ends up being a large it's the waste that the operators have to deal with for the life of the well, and also spills and releases, because again, spills and releases do occur, and those wastes have to be managed. So those are the sort of the main kinds of waste that the Oil and Gas Conservation Commission is involved with overseeing. Let's see, we've gone sort of over that. The groundwater. So we have analytical data from over 6,000 water wells and over 6,500 oil and gas wells. We've collected those samples ourselves, and operators have collected samples, and other agencies have collected those samples. We've collected samples for baseline studies. We've collected in response to complaints. There are orders in certain areas of the state where by order all oil and gas wells that are drilled, for all the oil and gas wells that are drilled, water wells in close proximity to that oil and gas well have to be, not all of the wells, but a selected number of the water wells have to be sampled. We also have rules. We've got rules up in the north, in the Wattenberg area that require groundwater monitoring. We have rules that apply to all coal bed methane development in all the parts of the state that require water sampling. And we also require water sampling as parts of investigation, remediation work plans, because often when groundwater is impacted, monitoring wells are installed, and that's how we determine the extent of the contamination of the groundwater. That's a picture of the state. Again, it shows the distribution of the samples that are currently in our database. The blue are the water well, or primarily water wells or springs also, and the green are the locations of the oil and gas wells that we have samples for. Where can you find some of these data? On our Trusty Dusty website over here in the library. We have area reports, and so we have a number of area baseline studies that we've done. We're currently working on one down in Elbert County where a lot of leasing is going on at the current time. How do you protect groundwater? It's, the number one way to protect groundwater is to make sure that the wells are properly drilled and completed, and isolation is maintained in the wellbore, that all the wastes and the products that are being produced, the oil and gas that's being produced, that it's properly stored, treated, and that waste can be reused and recycled when it can be done. Properly installing and maintaining the associated production equipment. That's very important. You'll see these tank batteries. There was a picture of a tank battery. So you need to make sure that those facilities are maintained, that the pipelines are maintained, to make sure that the hydrocarbon that's being produced isn't spilled or released. And that there's a rapid response, that operators are required to respond quickly to isolate the spills and to remediate the impacts. We do complaint response. We get complaints fairly often from landowners, asking or concerned whether or not their water well's been impacted. How do we go about investigating those complaints? We collect water samples from their water well. We can compare those. We collect water samples from the oil or gas samples, or both, more commonly if it's a gas issue. Compare those to the samples collected from the oil and gas wells. There are simple chemical ways to fingerprint gas, to fingerprint the water, and by comparison, you can determine whether or not the water in a water well has been impacted by produced water, or if the gas that occurs in a water well is gas that's coming from a gas well. So there are simple chemical techniques. We use composition or stable isotope analysis, and we have a huge, well, we've been doing it for the 15 years that I've worked for the Oil and Gas Conservation Commission, and actually even before I started working for the commission, that was a common way to investigate whether or not an impact had occurred from oil and gas activities. If we find an impact has occurred, the operator is required to mitigate that impact and to remediate it and to monitor it. We can use our database over here, and click on database, click on incidents and inspections, you can click on inspection, you can click on NOAV, you can click on complaint, spill, release, remediation, MIT. If you click on complaint, and you can click on complaints by county, by section, township, range, if you know a particular person that's complained, you can put their name into the complaint. You pull up that particular record, you'll see the scanned images of all of the data that have been compiled in response to that spill or release or that complaint. That's it for now. Look forward to your questions. Yeah, sure.
Hello, everyone. First, I want to thank the board and commission members and the members of the public that came out tonight. One of the reasons I got into this job at COGA, the Colorado Oil and Gas Association, is because I was working as an environmental scientist, and I thought there was really an absence of meaningful education and discussion about energy development. And so it's these kind of forums that I appreciate, that you take the time out of an evening to come and educate yourself, so thank you for that. As I go through, usually my hydraulic fracturing and drilling 101 takes about an hour, but I have 10 minutes tonight, so I will just say that I encourage you to take everything you hear tonight with a grain of salt, including what you hear from me. It's very easy when we talk about energy development to make sweeping, alarmist statements. It's more challenging to ponder, how did we get here? What vehicle did we use? What mode of transport? What's keeping the lights on? What's keeping our houses warm? What do we require to have affordable, responsible energy? And how are we going to have that going forward? We could spend hours just talking about that. So it's easy to be anti-something. It's more challenging to have these kind of meaningful discussions about what's appropriate, where is it appropriate, and how do we do it well? So that's the spirit with which I provide you my information. There's quite a bit of misinformation presented tonight, and I won't have time to address all of it, so I'll try to just address a few as we go through. And I know it doesn't make your jobs any easier to say you have to take everything with a grain of salt because you don't have time to study everything. But really, it is challenging, and it's difficult to know what's true and what's not. So I'll try to address a few things. And then we source all our information at koga.org, so you don't have to take my word for it. You can go to the third-party sources that provide the information. I'm Tisha Schuler, with the Colorado Oil and Gas Association. So because I only have 10 minutes, my thought was to provide the misinformation that I most often encounter when we have Q&A sessions, because many of you don't have the opportunity to ask questions tonight, or that I heard in the previous session and then provide some information, and then we have a lot more information available at our website. So let's talk a little bit about the process of drilling. So a common misconception is that hydraulic fracturing fluids are going to get directly into groundwater. And so we heard a lot tonight about what's in those fluids. And so in the same way that you have cleaning fluids under your sink that you don't want to get into your cooking, we have hydraulic fracturing fluids that we use that we don't want to get into groundwater. And let me show you what we do to ensure that. So the first thing is, one of the things you heard earlier tonight is that we don't know if the geology in between the shallow aquifer and the resource is adequate. So what I want to tell you is the Niobrara, which is the resource that is being talked about here, is at 7,000 feet below ground surface. And because I did quite a bit of permitting in this area in my last life, I can tell you that there's 4,000 feet of Pierre shale between the Niobrara and the shallow drinking water. That 7,000 feet is the equivalent of 10 Wells Fargo towers. That's the second tallest building in Denver. So there's really a significant distance here. And so the example you heard tonight was from shallow coal bed methane in a different part of the state, but I do want you to feel confident that you have this 4,000 feet of Pierre shale out here. So let's talk about what's the job of the well to protect the shallow groundwater resources. The first is the cement casing. So this is a layer of steel and cement whose sole purpose is to isolate and protect the shallow groundwater resource. It is imperative that casing be done correctly, and there are regulations designed specifically to make sure that that happens. So what you see here in purple is that surface aquifer casing, that the surface casing is designed to isolate the aquifer. And then there's another layer of cement and steel that's called the production casing, and its purpose is to isolate the oil and gas resource at depth. Because we know that oil and gas resources and the fluids that we're using to get them, we know we don't want those to come in contact with groundwater. We all up here would agree on that together. So the purpose of the cement and steel is to ensure that those resources are isolated. Another misperception is that hydraulic fracturing is not engineered. In fact, sometimes you'll see images that give you the impression of something like dynamite thrown into the ground. So I want to tell you that there are hundreds of people in Colorado alone spending their business days designing hydraulic fracturing operations. And let me just show you a little bit about what goes into that. So first, a ton of data is collected about the resource that you're going for, petrophysical information about the geology. There's fluid information, both about the resource that you're accessing, the oil and gas resource, and usually there's some water involved in that as well, and the fluid that you would use for the hydraulic fracture itself. The proppant is the tiny little sand grains that are used to hold those little tiny fractures open. Even the proppant is designed by engineers. And then all of that information is used to design what's called a very detailed hydraulic fracture. So they come up with a detailed pump schedule literally to the minute. If you sit in a trailer and watch a hydraulic fracturing operation, it is very boring. There's 3 screens. They're monitoring every fluid that's added. They're monitoring the pressure downhole. They're monitoring the pressure at the surface. This is a very detailed operation that's managed by engineers who specialize in this kind of operation. And then all of that information is tracked continually by the minute. One of the things you hear is that if a hydraulic fracture was happening, you wouldn't know if something went wrong. But in fact, if there was a failure of the casing, if there was a failure of the geology, you would see indication immediately in the pressure records. And the fracture would have to stop, it would have to be reported, and it would have to be investigated. Furthermore, these records have to be kept for 5 years. So if later you're worried that a hydraulic fracture operation had a problem, then the agency can investigate. They can do a forensic evaluation of exactly what happened during the fracture. I mention this because it is important that everyone have confidence that a lot of work and effort is going both into the design and the implementation and the record keeping of these operations. Another misperception, and you heard it tonight, is that drilling is getting riskier. In fact, we could think about R&D in every energy field. We're going to have to continue to develop our resources using a smaller footprint, more efficiently. We're going to have to be more efficient in every way, the way we get our resource and the way we use all of our energy. And so horizontal drilling is simply the next development in efficient development of our energy resources. So what you see on the left is the historic vertical boring. So if you can imagine the Niobrara as this horizontal plane, you would have this 1 4-inch hole to have to get that resource out of. So essentially you had to have a lot of vertical pads to get to that resource. With horizontal drilling, you can now make this 90-degree turn and go along the resource. What does that mean? It means it's incredibly efficient. You can have a much smaller surface footprint for the oil and gas resource that you get. Efficiency is our environmental friend. We have to be able to access our resources with less footprint, with less water, with less energy, and horizontal drilling is the next development with which we can do that. So to give you a visual of that, where you would have historically had to have many well pads, now you can locate fewer wells and on one well pad to access a resource that historically would have taken 32 wells. So there's a misperception of how much water is used in fracturing, and you heard one of those numbers tonight that I'd like to correct. But first, let me talk about water use in Colorado. The last time USGS did a comprehensive survey of water use in Colorado, they came up with all the different uses and they totaled it at the bottom. And I just want you to see that number, the totals at the bottom, because I'll show you them in another slide. And all this information is available also in a fact sheet on our website, because I'm going to go through some really detailed and boring calculations here. And I invite you to check our math and give us feedback if you think we made any mistakes. We've made that offer to many agencies and universities as well. And so far, our numbers are standing. So we did a calculation of how much water is being used in drilling and how much water might be used at a significant build-out. I will correct the number. There's about 70-some rigs in Colorado right now, and I've never heard a number of 200 drill rigs. We're fortunate if we can get an incremental increase of drill rigs in the state because of the economic activity that it creates. So let's just look at, but nonetheless, I'll make some extravagant predictions. In 2010, we had about 2,100 wells completed. In 2011, we know that we had about 500 horizontal wells permitted so far. So we're just looking ahead to 2012. What could a full build-out scenario look like? And I separate horizontal and vertical wells because they use very different water uses. So for horizontal wells, I went ahead and said, what if we doubled even the amount permitted? So that's a very big number, 1,000. We've surveyed our companies and the water that they're using in hydraulic fracturing, and the very maximum for total drilling and hydraulic fracturing for a horizontal well in Colorado is 5 million gallons. So I just want to correct, that's not 5 million per frac, it's 5 million total, including multi-stage hydraulic fracturing. And then I went ahead and said, okay, let's just say 1,500 more vertical wells. Those actually average 200,000 gallons, including hydraulic fracturing, but I went ahead and said 1 million gallons, just so nobody could accuse me of being stingy. So these are really big build-outs going forward, much more than we've seen so far. And then we said, how much would that total water use be of all the water used in the state? And what we came up with is that it's 13/100% of all water used in the state. So it's important to put water use in context. Of course, within a city or a community, 5 million gallons is critically important. Does the industry need to be at the table having discussions about what water is and will be used? Absolutely. Are we all going to have to make decisions about where to invest our water? Yes. But the perception that the oil and gas industry is going to dry up Colorado is simply incorrect. So another misperception, and Debbie Baldwin with COGCC covered this a bit, so I won't spend too much time on it, is we don't know. We don't know if oil and gas drilling is impacting Colorado. But in fact, we have quite a bit of data. So as Debbie covered, all complaints are investigated in Colorado, and operators have to participate in those investigations. And in the San Juan Basin, the southwest corner of the state, there's been mandatory groundwater sampling pre- and post-drilling for 10 years. And so all that data is publicly available, and it has indicated that oil and gas operations are not impacting groundwater in any systematic way in the San Juan Basin. And I'll talk a little bit about why we think that data is so important and why we think it needs to be taken statewide. So recently, as we see areas with new drilling activity, one of the greatest concerns is that this will drive people out of our county, or city. This will drive down our property values. So I just want to show one piece of data about that. You've already heard that Weld County has 38% of all wells in the state of Colorado, very active drilling area. And yet, in the last 10 years, population grew 40%. In addition, the residential property of values more than doubled. So we know that in a very busy drilling part of the state, that property values can grow. So let's talk about what the oil and gas industry is doing to engage with our communities in Colorado. One is the Frac Focus website. We hear a lot in public forums that people want to know what fluids are being used in drilling. And you've heard already that the COGCC, it has a rulemaking underway. The oil and gas industry supports full disclosure, and we're working as a party to the rulemaking hearings to ensure that hydraulic fracturing fluids will be disclosed. But in the meantime, companies are participating voluntarily in the Frac Focus website, and anyone here can go there, fracfocus.org, and see on a well-by-well basis what's being used. You can't see the details here, but you'll be able to see the details on the website. Every fluid is listed, the concentration it's used in the additive, and the concentration of total volume that's used, what it's used for, and the chemical names. So all that information is available on the website. And then Colorado is the first state in the country to develop a statewide baseline water sampling program. We've done that in conjunction with the regulatory agencies to ensure that it's a robust and meaningful program. We will have pre- and post-drilling samples at all new well pads in Colorado. And if you want to go to our website, we have the sampling and analysis program that we've developed on there. We've taken it to the environmental community, we've taken it to EPA, and we're in the process of having CDPHE review it as well. So there's a lot more information that could be had. There's much information on our website, and I invite you to take a look. We try to cite third parties for all of our information. Some of the examples of the fact sheet are shown here, and I look forward to being a part of the panel. Thank you.
Thank you, Tisha. At this point, this ends the presentation portion of the meeting. We're going to take a 5-minute break, and then when we return, the members of our advisory boards are going to have questions that the panel will be answering if they can. Thanks.
Stormwater management permits, construction permits from the Colorado Department of Public Health and the Environment, the Water Quality Control Division. And so, there's another permitting process there for where they have to have a stormwater management plan. But that set aside for our operations, our oil and gas inspectors can go out to a site and make sure that there are, at least from our perspective, adequate stormwater management, best management practices around the location to make sure that erosion isn't happening, that if you have a rain event, that the sediment's being stored on site, and then during the drilling, that the permit, the actual permit is put into the doghouse. They'll go out, they'll make sure how much surface casing have you set, what depth are you at, what fluids are you using. During the completion of the well, can witness how many, the cement plugs that are being put into, not the plugs, but the cement seals that are put into the well, see whether or not they've got cement returns to the surface to see, show that you've got isolation. Then after the well's already completed and on production, for the life of the well, they'll go out, they'll look to make sure that the wells are properly signed, there's proper signage on the wells, so there are emergency contact information on the wells, that the tanks themselves are properly placarded, so that if there's a condensate tank, it's placarded so that in the case of an emergency, people know there's flammable fluids in there, that the produced water tanks are properly placarded, that the equipment is operating properly, that there are not thief hatches open on tanks, that there are fences, if fences are required to isolate, to keep wildlife or children away or humans away. They'll look for that. They'll look for weeds on location. Some of our most, the common complaints we get are a lot of the complaints we get, weeds, noise, trash. So go out and look for those things, make just general housekeeping. Are there spills and releases that haven't been reported? Are there leaks from, pinhole leaks, small leaks? Is the secondary containment around the tanks, is it adequate? Does it meet the containment requirements? Is the secondary containment adequate to contain the spills? Should a release from a tank occur? You have something, yeah.
Do you have all that information? Is this on?
Yeah.
If you can push.
I know staffing is, how often are you able to go out and inspect these sites? I mean, is it one in every 20, 30, one in every 100? Do you do an inspection at every site during construction plus one post-construction?
Yeah, no, I showed you a statistic that last year we conducted 17,000 inspections. And so the inspection staff has set goals for percentages of how many drilling inspections are they going to, do, how many completion inspections are they going to do, how many routine inspections. But given that there are 47,000 active wells in the state, 17,000 inspections, that's, you could maybe estimate that a well is inspected once every 3 years. But the other advantage of having these central or the multi-well pads is that you can in fact inspect more wells from one inspection, but look at the operations that are associated with each one of those wells. So. Oh, and then we also do, if we get complaints from, the landowner, adjacent landowners, from local governments, we also always go out and do those inspections and also follow up with that.
I have one more thing. So when you're doing the inspections, how do you decide which ones you're going to inspect?
Again, I'm not the inspection manager, but they have a very, they look at the distribution of the wells, the different kinds of wells in different basins. They really have a fairly complicated, not complicated, but a matrix. They have plans and goals that each inspector has to reach. They also have all of our GIS data is available on their laptop computers with them in the field, and so they can, plan their routes so that they're looking at things efficiently. If they see a problem and they need to go back and re-inspect it, they can make those decisions also, so.
Thank you. The next.
Could I follow up?
Yeah, sorry.
Yeah, I think what Ms. Baldwin just said is quite accurate. Let's talk about a few cases where the red light wasn't acknowledged. In the case of Amy Ellsworth, where her domestic well had thermogenic gas in it, the state never determined a cause. Ms. Ellsworth then reached a financial resolution with the industry, and that property is now for sale with its contaminated well. There was usually when these inspectors find something wrong, it often applies just to a single well, but occasionally one of these inspectors will find out a problem with the red light, with the rules itself. In the case of Norm Anderson, owner of a domestic well not far from Gardner, in June of 2009, it was found after his complaint that his domestic well had thermogenic gas and toluene, factors that one of the commission's inspectors agreed was due to the industry. What that inspector noticed was that well that had, not far from Mr. Anderson's domestic well, the well drilled by Eddy Company, drilled in '84, had only had cement sufficient to meet the then rule. That rule was that the bottom of the surface casing cement can be just 150 feet below the nearest domestic well, not all the way through the aquifer, as Ms. Schuller implied. As a result, the Colorado Oil and Gas Commission ordered a complete, I'd call it kind of a Hail Mary. What they ordered was additional Bradenhead testing to see if other wells were leaking and if they were a mandatory re-squeeze job below that existing cement. It's interesting for this audience to know where that 25 square mile mandatory retesting was done. It comes right up to the Weld County line. It doesn't include Boulder County. So it comes right here between where we are and Union Reservoir. So the commission recognized that its prior rule of just sending surface casing to a certain depth and not all the way clear through the Laramie Fox Hills aquifer that's used so prominently here in the plains was indeed a mistake. Now, it's difficult to go back in and re-squeeze. Those petroleum engineers in the audience might recognize that, as Ms. Baldwin says, the time to do a cement job properly is when the hole is open and you see the cement return to the surface, so you know you have complete circulation behind that surface casing. Doing it subsequently to setting the bottom of that cement means that they have to open that casing and re-squeeze the cement in behind it. It's a very difficult thing to accomplish successfully. By the way, I should mention that the contamination that came from the Eddy well next to Mr. Anderson's well was recognized to have contaminated the Laramie Fox Hill aquifer. And there's no way that that was remedied. There was no ability, practical ability of the state to go down in after the fact and get that cleanup done.
All right, thank you. Next question for Tish and Debbie. In the case of baseline water samples, are these collected from monitoring wells specifically installed for this purpose?
Let's see. Oh, I left it on. Okay. And I guess I would maybe before I ask for some ground rules here, because it could end up being just a debate from different points of view here, and so I don't think we have time to do that. But, and if that's what we want, then I'd like time to have some rebuttal or some further explanation. But short of that, I'll just answer your question. No, the baseline samples aren't samples that are collected from monitoring wells specifically installed. What we recommend, what we've successfully done across the state, is to collect water samples from domestic water wells. Those are the water wells that people are using, that the local people are the most interested in the water that they're using and the wells that they're using. And so that's what we've used typically through all of our studies.
All right, thank you. And then, yes, to address your questions about ground rules, we are trying to just directly answer questions. This is not a time for a debate.
Okay,
Thank
so
you
if
for
the question
clarifying.
is, directed to me, am I the person that's going to answer the question, or will other people, does the questioner need to direct the question to the other people also?
Well, we've left it open where others can answer it if they
Okay.
feel like they should
Okay.
answer it, or if they have some kind of jurisdiction over that.
Okay.
So I'll try to help mediate that.
Follow up, then, I certainly agree with what you said. I have no problem with the state in its rather unique effort to go out and get this baseline testing in existing domestic wells. I didn't imply that there's anything wrong with it. What my implication is that it's insufficient to understand the science. In order to do first principle science, we need what the questioner is asking, a engineered monitoring well, so we make sure it doesn't run into problems with maintenance and we know where it's located. And let me point out, regardless of what your view is on state preemption, certainly the city could require engineered monitoring wells associated with each pad, and I encourage it to do so.
All right, our next question. What scientific studies have been performed on water wells during and after drilling operations? Have these studies included wells where fracking operations occurred? It's open to anybody who has any knowledge of this.
Yeah, Tisha mentioned us a report, actually several reports that are available on our website. In La Plata County, water wells down there are, for every oil and gas well that's been drilled, or nearly every oil and gas well that's been drilled, 2 water wells are sampled. They've been sampled before the well was drilled, after the well was drilled and completed, 3 years later, 6 years later, and then in some cases those samples have continued. So there's a body of data for the last over 10 years of data. And all of those wells have, well, I won't say all of them are fracked, but the majority of those wells have been fracked. The oil and gas wells, the coal bed methane wells, were fracked. And so we have a very large body of data that I think demonstrates that although there are instances in La Plata County where water wells have been impacted by oil and gas activities, there isn't a systemic problem of a degradation of the water throughout La Plata County. So I'd say in the United States, it's probably the most comprehensive body of data that can be used to help answer that question. And
Right, thank you.
If you don't mind. Yeah, I agree with what you said there. Let's set the La Plata County issue aside for a second. Again, we're trying to obtain scientific evidence of what fracking may cause. And in order to do that, these individual monitoring wells are quite important. You'll see at EPA study in Pavilion, the way it got its dispositive information was not just from sampling the shallower domestic wells, but they put in engineered monitoring wells to see what was happening in that location. And then with respect to some information that's available here in Weld County, I'm a little bit underwhelmed by the study that's online right now, the Greater Wattenberg study. It looked at just 9 domestic wells. Now, incidentally, all 9 of those domestic wells had biogenic gas. And one of the problems I have with the way state of Colorado makes a conclusion when it finds biogenic gas within a domestic well is they think that's a proof positive that the activity of nearby drilling for thermogenic gas didn't cause a biogenic gas to show up in a well. In fact, they're not looking at the cause. Writing with Professor Tony Angrafi and I, we've written that you could have a secondary effect. These pressure waves that go out well beyond the frac zone can have secondary consequences in a domestic well. And when I'm persuaded just by the citizens' information, when they're telling the state that my well has changed after a fracking event, I think we got to take that seriously. When the state goes out and finds only a certain type of isotopic gas not related to the deeper gas, that's really not conclusive that the oil and gas activity is not at fault. It just is not responding to the timing of these events. And I particularly enjoyed Commissioner Richard Allred's argument with the Halliburton representative just this week down at the in the state capitol. He was pressing on the same point you're looking for. What scientific studies are available? I'm afraid there's a dearth of those scientific studies. That's why EPA is doing an extensive nationwide study. It's looking at 5 existing well field sites, 1 in Colorado in the Raton Basin, and 4 others elsewhere. And then it's going to look at 2 of what we call really first principle science. It's going to look 2 other locations where there hasn't been drilling. In order to get at this complex question, you got to know the baseline conditions prior to drilling and after, and not just be relying on a domestic well owner's location.
And I'm going to have to object, or at least add, not object, but at least add another perspective to our investigation. Our conclusions are not just based on the analytical data. That we get the engineering staff involved, we'll go out, we look at the completion records of all the wells in the area, we'll do Bradenhead test when we get a water well complaint. We go look at the Bradenhead pressures for those wells, how they've been completed. We'll collect gas samples. If the Laramie Fox Hills aquifer in this area has coal seams in it. Those coal seams produce gas. And if the gas is if the oil and gas wellbore is going to serve as a conduit, then the gas that's in the Bradenhead would be the same biogenic gas that you're seeing in the water well. And we'll go and collect samples. If there is gas pressure in the Bradenhead, we'll collect samples. We do an engineering review. We do samples. We'll sample additional water wells in the area. And so to say that we're making that conclusion based only on the analytical data from the gas is not a correct statement.
All right, thank you. For the next question, of the 500 spills and leaks in 2010, what percentage are linked to horizontal drilling technology? Are more risks presented with this technology?
Let's see if I can remember. I think there were permitted about 170 permitted horizontal wells. Last year there would have been even a fewer number of those. So to be honest, we're not tracking them. We could figure that out, but I don't have that number, that we track the spill to the well regardless of whether it's vertical or horizontal. And so a lot of the spills and releases that occur or are discovered as production equipment is being replaced and repaired. And so really it's spills and releases not particularly from the wells themselves, although that can happen, but the waste management practices at the surface location. So it's really regardless of whether the well is vertical or horizontal.
Okay, thanks. Do oil and gas drillers have to obtain a well permit for any produced water?
A well permit. Maybe you could get some clarification on that, because I'm not sure what.
When the drilling occurs through the aquifer, there's produced water. There's a variable volume of that, I would assume.
Oh, you mean as they're drilling the hole down through the aquifers?
Yes.
Okay.
How do they use that water? How do they dispose of that water? Do they require a permit for that?
They don't require a permit for that process of just drilling down through the aquifer. They're actually use a mud system to keep fluids from flowing into or out of the well. And so, in fact, that drilling down through the Laramie Fox Hills, in the case around here, they may drill that surface casing in a day and then set the casing and set the cement. So they're really not producing water from the Laramie Fox Hills. They are trying to get down through it and get it isolated so water from the Denver or the Arapahoe, whatever the aquifers are, isn't flowing into the well.
All right, thank you. This question is for Tisha. Why are records only saved for 5 years?
That's the rule. That's how the rule's written.
Thanks.
Yeah. And I just say that under, in our 200 series rules, rule retention, it's not just those records, it's, all records for the well. We could read the rule to make it, exactly, so.
We did hear interesting testimony on Monday with respect to the fracking chemical disclosure issue. It came from Mr. James Martin of the Denver Water Board, representing the Colorado Public Utilities Commission, I guess that's called. And what Mr. Miller was pressing the Oil and Gas Commission with respect to the chemistry, that he wanted those records kept for a 40 or 50-year period. And it gets to the heart of this question, I think. Keeping records long might be required because these holes will be forever, and subsequent drilling may cause a prior well to be compromised.
We're not, if I can just comment, we're not purging our records. The Oil and Gas Conservation Commission's records aren't being purged after 5 years. They're kept in perpetuity. And all of the documents that are submitted by the operators that support the operations of the well, the drilling of the well, the completion of the well, the production of the well, those are available for as long as there'll be an Oil and Gas Conservation Commission. So.
All right, thank you. The next question is for Boulder County Parks and Open Space. What is essential to include in a surface agreement to protect open space? And then the follow-up, has Longmont contacted Boulder County to ask these questions?
I can tell you that our surface use agreement is a form document that has all kinds of things in there that we always want to consider on a piece of property. That includes whether or not the activities are going to affect agricultural activities or wetlands or riparian corridors, things like that, and we want to protect those things. So then we tailor the surface use requirements to the specific property, so it's hard to generalize. I can also tell you that I've given Brian Schumacher our form and a sample of our agreement that I'm sure he'd be happy to share with you.
So if I can just follow up on that. As part of our presentation to City Council on December 20th, we're going to be providing some just brief analysis and comparison of several surface use agreements, one being the standard agreement that Boulder County has provided, just to give council some examples of what they look like and what they typically entail. Some obviously are more detailed, such as Boulder County's is more detailed than some of the others that we've seen. So we'll be providing that information to council for their December 20th meeting.
Will those be posted online for citizens to have access to?
Yes, as part of the packet, the surface use agreements will actually be part of the packet to City Council for the December 20th meeting.
Which will be posted next Tuesday night. The next question is, what is Longmont's previous experience with top operating? Violations and one fine are listed online. What will we require differently this time in light of problems we had before?
I'll respond to that. So we have the one well, I think it's the Evans 6 well, that was completed by TOP a few years ago, back in 2003. We have had some sort of ongoing work with TOP to dealing with issues of the roadway maintenance in and out of the site. I think some issues with regards to ultimate screening of the wellhead. Issues that I believe, have resolved largely with regards to the reseeding of the site. And so the part of the question, what will be different? I suppose that what will be somewhat different is that we are working towards a probably more detailed surface use agreement on future areas if applications are made. But I think that's an inherent process that you go through, and tough to predict the future on how that'll be different. But other than we are, I think, learning from past experience, and would intend to have a surface use agreement that would be more explicit with regards to expectations.
Right, thank you. The next question, what are the negative impacts of seismic surveying Would the survey data help reduce the impact of oil and gas drilling?
Want me to take a shot at that? Okay. So the purpose of seismic is to identify the resource in more detail. So what we do know about the Niobrara is that it's not uniformly producing. So that means that there will be an exploration phase throughout the Front Range to identify whether or not you'll have a producing oil and gas resource. And we've had several well-known dry holes in the Niobrara already. So what companies do, because you don't want to drill a well if you're not going to need it, is they do 3D seismic to try to identify to the best of their ability what the likely sweet spots are, which means the producing areas, so that they can be judicious in where they may put an application to drill an exploration well. So there's an exploration phase that happens before a producing phase. And so the benefit of seismic is you have the opportunity to be more thoughtful about where to do your exploration wells. And then if you can identify, once you do an exploration well, you can essentially calibrate your seismic data to what you actually see subsurface. So where's the actual resource at each layer? How did it produce in reality compared to the seismic? And then you can use your seismic data in a later development phase to centralize your facilities. So we heard several times that ideally you want to minimize your surface footprint by having as many wells as possible on one pad. So seismic will give you the opportunity to say, where can we be the most efficient in our placement of wells?
Let me just follow up and say I generally agree. I don't think the seismic activity has much environmental impact. I mean, reasonable precautions. Can't be done when it's a muddy field. The equipment has to be assured it doesn't carry weeds, that kind of reasonable stuff. Let me point out that what she just said, that the data is used so that they can determine where the well is. Well, that means the industry and not you citizens.
The next question, if Longmont required closed-loop production, would that conflict with state requirements and/or industry practices in Northeast Colorado?
You know, as part of the 2A process, permits are the surface disturbance in the areas that the well pad's going to be located in are looked at. And so in areas where there's shallow groundwater or in close proximity to surface water, there have been conditions of approval placed on permits that have required closed-loop drilling. But I would just say that most of the major oil and gas operators are using closed-loop systems. But there are special rigs that are required that can accommodate that. And so if you're a smaller operator that doesn't have as much access because you're not drilling as many wells, you may be using a rig that is not equipped to drill a well using closed-loop systems. So that's a fact. That's a reality of the technology that different operators use. So if the operator has that technology available, they would probably be willing to accommodate that requirement. If they don't have that technology available, then they might need to use a drilling pit, then that pit needs to be properly lined, properly isolated, and properly maintained. So.
Let me follow up on that. Colorado has a perfectly good rule on closed-loop systems. It's quite detailed, specific. It says that the fracking fluids can go to a pit just very temporarily, less than 24 hours. But as Ms. Baldwin answered, I haven't seen a case where the director is ordering it when it's not volunteered by the industry. It's inconceivable to me that there would be open pit systems drilled here. We're in a non-attainment area for ozone. These horizontal wells release enormous amounts of methane and volatile organic compounds. According to EPA, 150 times more than a vertical well. So I wouldn't accept her answer that I'm little and I can't afford what the big guys have. And this would be a good place for your city attorney to focus on if you do have an operator that says they're unwilling and the state isn't ordering it, then it seems to me the city has clearly not preempted a common to order such a closed-loop system because it's common. I think Ms. Baldwin said it may be 90% of the time. And not only does the industry have the capability of this, according to EPA, when it does so, it can make money because it's capturing more methane to sell into the system. So it's also beneficial in terms of maximizing the recovery of the resource. I would strongly advise you, under no circumstances, to let drilling without closed loop occur.
And I'd just comment, I think, Wes, you've probably misquoted a rule. I think what you're talking about are the green completions. That's not what they're talking about. They're talking about closed-loop drilling. It's two different animals. And so closed-loop drilling, there is not a requirement that commonly operators are doing it. They're doing it more and more often, but it is his statement that it is required by our rules isn't true. Green completions are required, and it's a different animal.
Okay, the next question is a follow-up on seismic surveying.
Yeah. Okay, I'd just maybe quickly say that when when you've fracked the well, that you've injected fluids, you've put fluids and proppant down into the well to fracture the rocks, to open up the rocks, and then you release the pressure, and so that the material that was in the well comes back out of the well. And so in areas where there's a good, where it's a developed field, you can direct those, the flowback gases and the fluids into tanks and into separators, and then put the gas into pipelines. So that's absolutely something that operators strive to do. But there are again, there needs to be a certain infrastructure that is already in place in order to have that happen. It's our rule 805, and the 805 odors and dust rules talks about green completions.
Okay, and a follow-up to seismic surveying, the question is, who does Cougar sell the information to, and do they continue to make money off the sale of the information?
I would just say an operator would probably, hire them as to run the survey on their behalf, and it just depends. Those are private contracts, I don't. It might be unique to a particular operator. It might be that they can sell it to other operators. I guess I'm not sure.
Can I just address that? Typically, the seismic data is considered proprietary by whoever pays for it. They can license it out to other people, but it's generally not available to the public and certainly not to other operators who are in competition.
Next question, have other Colorado communities successfully banned oil and gas drilling and fracking within their city-county limits? If so, how was this accomplished?
No, I'm not aware of any city that has done a ban. I mentioned that issue about Grand Junction and Palisades working in their watershed to get green fracking fluids. That was quite a significant struggle. But no city has done so, even though it's my view and that of my colleague that under Colorado Home Rule, under constitutional provisions in the state constitution, that a home rule city could do so.
Let me just correct, I think what was maybe an inadvertent misstatement earlier by Wes. Whether you like it or not, there's a Colorado Supreme Court decision that says a home rule city cannot ban drilling within the city limits. And unless the Colorado Supreme Court changes its mind, all of us are bound by that.
You want to talk?
I was just going to say that because of the leasing activity happening across the Front Range, we're seeing a lot of interest from counties and municipalities with this question in mind. And what I will say is that we do have a model within counties and within that framework, within the cities, within those counties, to meet monthly with planning officials, because ultimately what becomes fundamental to the citizens of that community are a lot of the planning components. So where will wells be sited? How will they be located? What's the appropriate infrastructure and where should it be located? How can we manage dust and traffic? And so there is a way that industry can work in a very meaningful way with communities and stakeholders to ensure that planning is done to address community needs. And so you'll see, whether it's in Weld County or in multiple counties on the western slope, that there's monthly meetings to address a lot of the day-by-day concerns that come up within communities.
All right, the next question says, where does the water come from and where does it go after fracking?
It is, oil and gas exploration and production is an industrial activity. So operators need to obtain that water the way any other industry would obtain it, or agriculture would obtain it. They have to lease it or they have to purchase it. They also can reuse and recycle, and that's becoming more and more widely used by operators, to reuse and recycle the fluids that they're using and the produced water. So, there are municipalities can sell water or lease water to operators. There are some private or water wells that have been permitted through the State Engineers Department that are specifically permitted to be industrial use, or wells that can supply water for industrial uses. So that can be done. Private landowners that have what are considered to be non-tributary water can make arrangements to, if the water hasn't been designated as for agricultural purposes. So there is a possibility that you could, if you had agricultural water that you had a right to use for agricultural purposes, you could get a temporary change in that designation from the state engineers, but really practically that's not likely to occur, and I don't think it's been done yet, but that is a possibility. But they obtain the water the way any other industry would obtain the water, by buying it or leasing it.
Let me follow up. I agree, Debbie. And when I was watching Tisha Schuller put up her information about how much water is needed for hydraulic fracking, some 5 million gallons, she thought, per well, I have a disagreement on that number. The problem is this. We don't have a state process to understand the cumulative water demand from this industry. Even though we have an environmental impact statement process going on for the Gailton Reservoir, the Northern Integrated Supply Project, even though we have an EIS going on for Gross Reservoir and other water supply projects, none of those describe the potential future use by this industry of significant volumes of water. Now, the other disagreement I had with Tisha wasn't so much a disagreement. She was projecting how much water might be needed for the next 1,000 wells. Well, we may see 100,000 wells within just the next 20 years. And if my numbers that I think that I can get from the industry, which is a higher amount of water times 100,000 wells, we can easily get up to a water demand equal to the Front Range community demand. And in a state where we're also facing climate risk, even moving this water to the highest bidder, as Ms. Baldwin's implying surely can occur, may be detrimental to our streams. We lack a statewide process for this planning. I can't give you any numbers from your state government with due respect to how much water this industry will demand over the next several decades. They don't exist.
All right, the next question. Is there an existing technology to trap methane gas that escapes from fracked wells as fluids are retracted?
Well, and I just direct you to the green completions. It's a concept that operators try and do. It cannot be done in all situations, but that it is something that when it can be done is very effective and can be where you're directing the gas immediately into a pipeline and can be sold. But that requires the infrastructure of a pipeline and various reservoir pressures and things. So if it's when it's technologically feasible, that's the preferred way of doing it.
Let me just follow up. When it's not technologically feasible, it's burned. When it's not technologically convenient for the industry, this resource is wasted. It's flared. Look what's happening with the Bakken oil development in North Dakota. I don't know if that's occurring yet in the Niobrara because it's being developed in a rather mature location where the gas pipelines may be well available. But as it moves south, we may see this nighttime flaring of unwanted gas simply because it doesn't make a appropriate return on investment somehow for the industry. And I don't understand Ms. Baldwin's position that where it can be done, it may be done by the industry. EPA intends to make a pretty ironclad demand on the industry that green completions, this what I call closed loop, that is closed loop with respect to the fracking fluid, all of them will eventually, under EPA's proposed rule, be required to go to that green completion rule. I invite you to follow that and see if it actually becomes a federal rule as planned next February. And then one other aspect of this. What's coming out of the fracking fluid when it comes back to an open pit where there's not a green completion are hazardous air pollutants that are not detectable by odor. Now, the state has a response here that says, you know, if you have a complaint, it might be due to odor, as indeed it might. It might be an H2S or some other compound that has an odor to it. But these hazardous air pollutants that I talk about that are carcinogenic and nerve agents are odorless themselves. So we can't rely on an odor rule. We have to rely on two possible choices. One, we just talked about green completions, which will cut it down some but not eliminate it. Two, there could be green fracking fluids, as Halliburton is now advertising, which may cut down on some significantly on that type of hazardous air pollution risk to the community.
All right, in a follow-up to that question, there's another one. Can cities require documentation and measurements of methane of the air as fluids are retracted?
You know, there is, operators in the Front Range do get air permits from the Air Pollution Control Department because it's a non-attainment area. So there's a I think pretty much every well probably has an air permit. But that didn't really answer the question. The question was, could you monitor the methane, the flow back? And you could probably. I mean, it's not inconceivable. That is technology it's available to do air quality monitoring.
Yes, let me follow up. There's the group out of Battlement Mesa where the citizens themselves have taken it on to do hazardous air monitoring because they're unsatisfied with the state's answer. And think how difficult it is to get a peak air sample. Maybe there's a fire at a well, maybe there's just a lot of odor. It may not last a long time. So it is difficult to get these synoptic samples of air quality, but nevertheless it's possible, and it's possible for citizens. For a long time, citizens did a great deal of stream monitoring. Even groundwater monitoring was commonly collected and then taken to the lab. A citizen can do it. Well, new technology has come along. I can introduce you to this Mr. Dave Delaney who's doing it. Costs about $250 a sample. I would encourage people in Weld County to consider that. It does take a rigorous teamwork. It has to be verified in a QA/QC process. But ultimately what they're doing is just putting a vacuum within a small bucket, going out to an event, and then if they have a particular odor or some event they want to monitor, they simply open the valve and the vacuum in the bucket allows the sample to be pulled in. EPA does a lot of ambient monitoring along with the state of Colorado CDPHE, but that'll be confined to just a few pollutants, ozone, particulate matter, nitrogen oxide in the air. Now, ozone, it turns out, is as a result of releasing both nitrogen oxide and these volatile organic compounds. And it wasn't until just 18 months ago that EPA revised its estimates of how much volatile organic compounds are coming from exploration up by a factor of 10. EPA looked at the whole industry-wide, and said they had grossly underestimated the amount of volatile organic compounds. You are armed with one tool here on the Front Range, ironically. The tool is that we're not meeting our health standards for ozone, and that can be a useful tool as the state is now doing, to crack down on these volatile organic compounds.
So I've avoided responding to every piece of misinformation provided, but I think it's important to let you know that the citizen air brigades that were just recently cited were determined to be unscientific by the CDPHE in a letter that's publicly available. EPA did their own study and did not come to the same conclusion. So although earlier we heard an emphasis on rigorous scientific study, this is just an example of information provided that has in fact been deemed to be not rigorous scientific study.
All right, the next question. Where is the L0080 well located in Longmont that is producing?
That's the well that's on the, what's called the High Plains Preserve on the old owned by the general fund, just south of the old landfill.
You know, and I would just, I mean, if you maybe have that posted on your, you know, some maps or website, county website, but you can absolutely find that well on the COGCC well website, GIS map. You can zoom in, see, you know, look at any well in the state.
All right, the next question. What are the rights of a surface owner and what can Longmont ask for that we have not?
The rights of a surface owner are if the property is not leased, surface owner can keep anybody off the property until there is a lease. If the surface owner also owns the minerals, the surface owner can refuse to issue a lease and thereby protect the land forever. If in an example, the surface owner does not own the minerals and Longmont owns the surface, there is what I referred to earlier as a reasonable accommodation doctrine that is embedded in Colorado law, and the reasonable accommodation doctrine, taken to its extreme, requires both the mineral owner and the surface owner to respect each other's rights and try to accommodate. Now, where the rubber meets the road on that is if you have a dispute about what is or is not a reasonable accommodation, you can end up in a court and have a jury decide that issue if you really can't resolve it. I would say in 98% of the cases that I've seen, a surface use agreement is used to resolve those kinds of disputes. And in a surface use agreement, it's like any other contract or bargain. You bargain for whatever you can get.
Mr. Barber, you might also explain how a landowner might be force pooled even with a lease denial.
There is a law in Colorado that says if you own mineral rights within, let's just use an example of a 160-acre section, and an oil company owns a lease on 50% of the minerals and you own the other 50% of the minerals and do not want to lease your property, absolutely, positively do not. The oil company can go into the Oil and Gas Commission and ask for an order requiring, in essence, you to lease the minerals to the oil company. And if the Oil and Gas Commission agrees with that request and enters an order, your minerals will be deemed leased to the company that already has the lease. You will receive a royalty, or you can choose to participate in a well. I'll say this, in general, the laws in Colorado are pro-development more than they are pro-preservation as far as oil and gas is concerned. And I think in a lot of respects that is an historic attribute of this state, which, you know, came up as a result of mining and oil and gas and other extractive industries. And you know, whether that is just the way the law is written as it is now. Now, having said that, I just had a situation where there was a force pooling threat made, and the landowner was able to negotiate what we call a non-surface occupancy agreement, an NSO, so that in exchange for not contesting the forest pooling, the landowner got a a promise, a condition, a covenant from the oil company that there would never be any disturbance of the surface. So, again, that's part of the negotiation process that often occurs in these times where you have conflict and you can't resolve things as one side or the other would like it resolved.
And I might, if I can, just add something else, because I do realize that the term forced pooling sounds pretty horrible. You know, I'll be frank, it's just, doesn't sound very comfy-wumphy. But if you had, say, coal that's a solid, and you didn't, and somebody wanted to lease the coal minerals, and you said, I don't want to lease my coal mining, the coal for mining, you can not mine that coal, and therefore your mineral rights can be protected. But in the case of oil and gas, those fluids and gas move underground. And so it really is, on some levels, a way to protect the mineral owner, even though maybe the mineral owner doesn't want to be protected, but at least their minerals aren't going to be produced and they get no benefit from it. So if they're in a forced pool, you know, when they're forced pooled, those minerals will be produced, they will get a royalty, and so it may not seem fair, but at least somebody's not allowed to just steal their minerals and give them nothing. So I guess that's another part of the forced pooling.
Okay, thank you.
Let me just follow up. At the break, the city attorney came to me and was quite upset with our last slide there, that I had indicated that home rule cities might be able to ban it under the constitutional provisions. I'm not a lawyer, but I have been to education on this regard, and if you see me afterwards, I can tell you how to get additional education. It's principally from the Community Environmental Legal Defense Fund out of Pennsylvania. You look at that website in particular. We have 2 schools on this subject coming up, one in Boulder and one in Denver in February. So see me after the event if you're interested in that.
All right, next question. What state and federal laws protect wildlife in the Union Reservoir area and other areas in Longmont that have been targeted for drilling?
You know, I'd have to, you know, one of the things that we have on our website is a layer about wildlife, and we have a consultation with the Division of Wildlife. So on federal land and on, federal land, the U.S. Fish and Wildlife Service has a great deal, and the BLM, they have a large role. On private land, it's a little different relationship. And so the the Colorado Division of Wildlife can be asked to consult and make recommendations about how to mitigate or how to protect wildlife. But it is different on private property versus federal property.
So I was just gonna, I'll just elaborate on that a bit. So the surface owner really dominates how you manage vegetation and wildlife on the surface. Now, operators across Colorado have voluntarily engaged in wildlife mitigation plans covering hundreds of thousands of acres. I think the latest number was 800,000 acres in the state of Colorado. So if the surface owner is willing, then operators can work with the surface owner to come up with a wildlife mitigation plan. But operators cannot dictate to the surface owner how they'll deal with wildlife.
This is one of those areas where I talked about getting on the front end of something. A condition of approval before a drilling permit is granted could include wildlife mitigation, wildlife protection, just like it could include water mitigation, water protection, air, et cetera, et cetera. So if there's a particular concern about wildlife, that would be the place to initially try to deal with it, which is at the commission during the permitting phase. And again, your local government designee here in Longmont gets a copy of every permit application, and I'm not sure how that is handled in terms of disseminating it to the public, but it's certainly available on the Oil and Gas Commission website whenever a well permit application is requested.
Let me just follow up. I'm not the particular expert on this, but I'm quite familiar with the man who is. I would invite that questioner to call Pete Ramirez, Fish and Wildlife Service in Cheyenne, talk over some of his frustrations of trying to control what he calls incidental take for endangered species. Incidental take means, you know, one of these migratory birds may have unfortunately come to their end in one of these open ponds. So do contact Pete Ramirez in respect to that. Here on the Front Range, I know one of the key issues has been the sage grouse issue and how their leks are managed. And if that's relevant to your open space, Mr. Ramirez would be most useful in guiding you through that process to make sure those particular sage grouse leks are protected.
And I would just follow up by saying, I mean, if this fellow's in Wyoming, you might want to consult with your, the people that are local to Colorado that would be more familiar with Colorado's wildlife and management practices. I know we have an active relationship with the U.S. Fish and Wildlife Service. Frequently, you'll do inspections to make sure that the migratory birds, because there is a large migratory corridor, bird corridor in the eastern plains, that those birds are protected. Recently, we changed a rule, or added a rule that required these little conical hats to sit on top of stacks to make sure that birds don't perch on heated treaters or where they could come into heat. So we've accommodated, we've created rules that help to protect wildlife.
And the next question follows up on this. It asks, does the U.S. Migratory Bird Act or the Endangered Species Act supersede Colorado laws that grant supremacy to mineral rights ownerships?
I think the Threatened and Endangered Species Act is very powerful. Yeah, there's no question about that.
So the
I
migratory
think in
bird-
general, the answer is yes.
Right.
Air, water, endangered species, the federal law will almost always supersede a state law.
One way that plays out right here in this community is Colorado's obligation to have seasonal flow in the South Platte River. Colorado, Wyoming, and Nebraska all were compelled under the Endangered Species Act to manage the main stem of the river in Nebraska so that it would remain a critical habitat for the whooping crane. So I agree with the commenters, you know, that can trump, especially on such a large scale. In that case, it trumped how much water Colorado could remove from the South Platte River without coming afoul, no pun intended, without coming at conflict with these endangered species scientists that concluded that water was essential in the spring for the continuation of the whooping crane species.
So to return to the question, the Migratory Bird Treaty Act applies to all of us, so whether it's on private land or not, and threatened and endangered species as well.
What is the state statute that the Colorado and Gas Conservation Commission uses to justify its regulations?
It's the Colorado Oil and Gas Conservation Act, Title 34, Article 60, and it's available on our website. It was passed in 1951, I believe, so.
Thank you.
Let me just point out that there's an interesting case before the Colorado Supreme Court brought by citizens who were trying to get a hearing to the Colorado Oil and Gas Commission prior to an APD. So far, the Colorado Oil and Gas Commission has denied the public's right to have a hearing. It went to the Supreme Court last week. We should have a reading from the court by the end of the year, perhaps. And if the court agrees, that would set up a process that impacted citizens could obtain a right prior to the commission, obtain a right to a hearing prior to the commission issuing an application for permit to drill.
And I would just say that there are certain people that do have a right to ask for a hearing on the permit. It is, I'm trying to find the language, somebody help me. It's that what Wes is talking about are people that are just tangential to the actual drilling operations, that they don't own the property, they don't own the minerals, they aren't living in close proximity. So.
All right, thank you. The next question, can municipalities require pitless drilling?
Yes.
And I guess, I think we've covered that. that you could require it, but it may not be possible for all operators to comply with that. And I would recommend in that situation that you'd be working with the Oil and Gas Conservation Commission on the Form 2A process, where the evaluation of whether or not that should be a condition of approval on our permit is necessary, and have your local governmental designee work with the staff, the Oil and Gas Commission staff.
Yes, and I encourage you to read the paper by Baumgartner and Robbins with respect to that very point of whether a city or county is preempted by the state. So what might come up is, just as Ms. Baldwin implied, perhaps the State Oil and Gas Commission doesn't think a pitless rule is necessary in that particular application. I think when you read this rule on preemption by these two preeminent Colorado attorneys, you understand that a city and county does have that right.
Let me just add that Rule 317B of the Colorado Oil and Gas Commission Rules and Regulations appears by my reading to require pitless drilling within 2,640 feet of any, what they call a water supply segment, and essentially a reservoir that would supply water, or a stream that would supply water to a reservoir.
You know, and I might just add, those are segments that have been designated by the by the Health Department, the Water Quality Control Commission. So not every reservoir is necessarily doesn't necessarily fall under the 317B rule. If you want to see, you can go on the website and on the maps, and it pulls up where those surface water supply segments are located.
So you wouldn't expect Longmont's Union Reservoir to be covered under 317?
You know, I'd have to pull up the map and look and see. And again, if it's supplying drinking, my understanding it was an irrigation, you know, primarily served irrigation. But again, that's something that you could, you know, talk to the Water Quality Control Commission about. I really am not, you'd need to talk to the people that would make that determination.
All right, thank you. The next question, if a well has been constructed and then it's inspected and a deficiency is found, what can be done?
Well, I mean, they'll get you know, there's sort of a tiered approach to enforcement that can start with just something simple as a failed inspection, where an operator says there's weeds. You writes a failed inspection. Again, all of the inspections for all of the wells are available on our website. If you know the API number or know the location of the well, you can pull it up and see those inspection reports. There'll be corrective action required. And so, I'm sorry, I was off on a say the question again.
If a deficiency is found in a well after it's completed, what is done?
Yeah. After, you mean a deficiency in how the well has been constructed, or how okay. So that after the well's been drilled and completed, the operators have to submit the completion reports on that well. And so those are reviewed by the engineers, and let's just say, and they'll run the geophysical logs, they run the cement bond logs to see where the cement seals are or have been placed in the wellbore. And if the cement isn't adequate to isolate the producing formation or the groundwater in compliance with the regulations, then the operator is required to remediate it. They'll have to perforate the casing and do a squeeze cement job, or whatever, you know, some other remediation thing may need to be done. The good news is that doesn't happen too often, but it does happen. But there are mechanical ways to correct the problem.
It doesn't happen very often, but the state did require a 25 square mile area in the greater Wattenberg field to be tested just as she's describing, because of earlier rules by the commission allowing the surface casing to be cemented just 150 feet below the nearest domestic well. That created a problem. And I particularly invite you to look at the Eddy Oil Company's well, south of Mr. Anderson's well. I can get you the numbers on that after the meeting. When that well was found to have a leak as a result of mechanical integrity, a leak that was known to cause contamination in the Laramie Fox Hills, the Laramie Fox Hills aquifer wasn't cleaned up, the well was plugged and abandoned. And I mentioned I mentioned earlier tonight a case about coal bed methane, which is admittedly significantly different than drilling below the Pier Shale here. But this case near the town of La Vida, when some 20 or 30 homes showed up with high methane, the state did work with the operator to try to come up with a remedy, a mitigation, as Ms. Baldwin's describing. For whatever reason, the company then abandoned that remedy, and in September of this year, Petroglyph was issued an order to abandon its wells and leave that contamination in the ground.
You know, I would just go on with, to follow on with this Bradenhead testing program. Wes is right that as, you know, if wells that were drilled 70 years, or not 70, but maybe 40 years ago, 30 years ago, at least in some of those wells, the surface casing, at least in the greater Wattenberg area, may not be sufficient to have completely covered the Laramie Fox Hills or the aquifers in the area. And so now when operators are going back to do additional work on those wells, they're required, our engineering staff reviews how the wells were completed, where's the cement plugs, and they require remedial cementing on all of those wells when the operator goes in to do additional work on the well. And that Bradenhead monitoring program is not, he was making it sound like it's a terrible thing. It's actually a very good thing so that we can identify wells that have some potential to cause a problem and we can get them remediated. We have a Bradenhead monitoring program down in La Plata County also. It's a way to figure out whether or not there are problems with these wells, and if there are problems, to get them remediated or get the problem fixed.
If Longmont did not agree with the wildlife impact conclusions of the Colorado Division of Wildlife, could it set different requirements?
You know, I'd like to think we could sit down with the Division of Wildlife and work that out. Speculating on that, if you had an example, I just don't see well, let me say, the Division of Wildlife probably, you know, again, on private land, the Division of Wildlife has less control about what can and can't be done. So it really would probably fall to the local government, but you'd maybe want to look to the Division of Wildlife for some suggestions, use their expertise on, you know, should there be some restrictions on, during nesting times, or in other places in the state where there's mule-eared deer, migration pathways, there, or wintering habitat, so that, again, you make it sound like it's impossible to negotiate or to use them and to come to an agreement that works for everybody. So I'd like to think it could be done.
I'll just add that a lot of the questions presuppose this sort of hostile engagement. And in fact, our preferred way of engaging with any surface owner is to sit down and talk about what the objectives are and come to as many reasonable compromises as possible. And if the city of Longmont engages that way, there's many agencies that will participate, and we do that on a site-by-site basis, but we also would do it statewide, even sitting down with stakeholder groups and talking about ways that we can work together. So the presumption of hostility could be a self-fulfilling prophecy, and I would invite the city of Longmont to bring their interested stakeholders to the table and talk about the opportunities to work together.
Boy, I agree. It doesn't have to presume of presumption of hostility, but I certainly invite you to look at others who are in your same boat. The Colorado Land Board is recently proposing to lease some 30,000 acres that comprise the Aurora Lowry bombing range. It's an incredible prairie ecosystem owned by the Colorado Land Board, who is in, as your city is, in the catbird seat. They own both the land and the mineral. They had proposed various techniques to avoid some of the prairie dog towns within that prairie complex. the vast estate that they own. This is just right next and south and east of Aurora Reservoir. Unfortunately, when negotiations were completed, the Colorado Oil and Gas Commission staff convinced the State Land Board not to apply additional restrictions. The Colorado Land Board had intended to apply closed-loop situations near these prairie dog towns. That was left off the table.
All right, the next question. What state or federal laws govern methane gas as it relates to climate change?
Actually, I don't think there are any, because it's not a VOC. It's not, I mean, it is a 26 times greater potential for being a greenhouse gas than carbon dioxide, but methane is not, not considered, volatile organic compound. It's the heavier compounds, the benzene, toluene, ethylbenzene, xylenes, those are the volatile organic compounds that are. So, but does that mean that operators should be allowed just to let methane, methane emissions, go everywhere? And the answer is no. There's safety issues related to methane. Methane's flammable, and so you want to minimize how much, the leaks around the wellheads, leaks around the pipes. They're trying to sell this commodity, not just allow it to be a fugitive emission.
So I'm not an expert on air regulation, but EPA does have a regulation in place that operators have to track their greenhouse gas emissions. So as far as I know, that's the only greenhouse gas related rule that's out there right now, but operators do have to track, and that went into place this year.
Yes, that's right. EPA is requiring a reporting rule. EPA was forced into this position of regulating greenhouse gases as a result of a Supreme Court decision brought by the state of Massachusetts. So we're just now moving towards reporting requirements. I encourage you to look at California's AB 42 rule, which is much more aggressive in this regard and requiring greenhouse gas capture in many situations. I think here the issue for us is first to get the education. Look at Dr. Tony Angrafia's and Robert Howarth's report out of Cornell, where they're simply tracking the total methane released from the oil and gas industry, since it ranges from 3.5% to almost 8% of what they produce. And unfortunately, methane is significantly more heat trapping than carbon dioxide, especially in the short term. There's just science reported just 2 months ago that over a 20-year period, methane is indeed 105 times more effective at capturing solar heat than carbon dioxide over a 20-year period. So I think we've got to be cautious here. We've been sold a bill of goods that that natural gas itself is going to bridge our future to a green, renewable future. It's going to be as dirty unless this gas is captured as coal itself.
So again, I would make note that the Howarth Cornell report has been widely debunked, and more recent studies have been done on the greenhouse gas effects of natural gas, including reports by MIT and one commissioned by the Sierra Club.
All right, next question. What is the lifespan of one of the multi-directional drill sites? What is the lifespan?
Let me answer that question. When clients come to me and want to lease their property, I tell them, you better expect that if a well is drilled, it'll be there longer than you're alive.
Probably safe, unless you're very, very young.
All right.
And I would just say that there are wells out in, in Weld County that have been producing for 60, 70 years. There's some wells down in Fremont County that have been producing for 100 years. So, again, it's, and with improved technology you can extend the life of those wells so that you're able to recover more resource out of the formations, the hydrocarbon-bearing formations.
All right, thank you. The city of Longmont has a water body near existing well sites as well as proposed well site. What precautions are in place to prevent upward seepage of oils and fluids to this water body?
Well, I guess, I'd say really where we see problems of impacts to surface water, except under very extreme few situations, I won't say it has never happened, but it is, the greater potential is from surface spills and releases that occur at the surface. That we've talked about the geology out in this area. We've got maybe 700 or 800 feet of the shallow aquifers that sit on top of the Pierce Shale. Then you've got 4,000 feet of Pierce Shale, and then you're getting down to maybe 7,000 feet below the ground surface. So I won't say it's impossible, but the likelihood of having materials come up from that depth, very, very, very low potential. From surface, spills and releases, those are the things that we really need to focus on, where you need to keep your attention on properly managing your waste, properly constructing your facilities, properly constructing secondary containment. That's really what should be focused. Proper stormwater management controls, best management practices to keep erosion from occurring and getting into surface water.
Let me just follow up and say I certainly agree. I mean, I think it's spills rather than the risk of improperly constructed well. And so spills are the significant problem. Colorado doesn't require, though, spill reporting for less than 5 barrels. And my understanding is that the recent Suncor refinery, I'm sure you've all read about that in the paper, which resulted in a release of pretty high concentrations of benzene to Sand Creek at the South Platte Conference, that actually the total release from that spill may be under 5 barrels. So you've got that issue. You know, you could be proximate to your Union Reservoir, and the operator isn't obligated to report a relatively small spill.
I almost have to butt in right this minute that I'm sorry, but to be disrespectful, but in fact, the rule actually says that if a spill of any size impacts waters of the state, a public byway, residences, livestock, occupied structures, those have to be reported, regardless of the size, they have to be reported within 24 hours. So what he's saying is not correct.
Well, I'm saying if it goes on the soil and it has an impact to that. Most of these spills will be set back some distance. I certainly agree that the stormwater prevention is the key there. You need that adequate berming around all these facilities so you don't have release of these fluids across the surface. But I'll point out that if a spill is into the soil and it hasn't affected any of those entities and it's less than 5 barrels, no reporting is obligated.
No reporting is obligated, but the operator is still obligated to control the spill and remediate it.
All right. What health protections are guaranteed to residents or visitors in the area of drilling to protect those with breathing, lung, or asthmatic conditions?
So all facilities are permitted under the CDPHE, which is the Health Department's Air Pollution Control Division. So I don't exactly understand the question, but all sites are permitted according to the laws of the state of Colorado, which are delegated to them from EPA.
And collectively, all of our driving, all of our industry, plus the oil and gas industry here in the Front Range, are causing this community to exceed the ozone standard. Ozone, currently set at 75 parts per million, will cause like a burn, like a sunburn in your lung. The president was offered by the administrator of EPA, based on her best science, to lower that standard. That was delayed. So I think scientifically we have good reason to be questioning the current standard. The science was there according to the EPA.
And as long as we're not answering the question, relevant to the health of lungs, the most important thing we can do is convert coal-fired power to natural gas-fired power, which is definitively proven to reduce the sources of pollution that most affect health, and that is well documented by the health community.
Oh, I agree there. And you'll see Colorado moving in that direction to reduce some of our coal-fired power plants and replace them with natural gas-fired. After all, natural gas, once it's burned, doesn't release that sulfur dioxide, nitrogen oxide, particulate matter that coal does. So she's certainly right in switching. We'll do some local public health protection with respect to those gases. What we don't know is the...
Make sure we stick to this question,
Okay,
please.
this question is complicated. I don't think we'll ever figure out the complex synergy of these hazardous air pollutants effects on the human body. That's according to Gus Stoltz, the
Well,
professor.
that's certainly true for all sources of air pollution, of which the worst is well documented to be the cars that we all drive, all forms of transportation, and the power sector. It's well documented that the vast majority of pollution is provided for those two sectors, so I suggest we move on to the next question.
Yeah, I agree as well.
Well, maybe we'll find out that's correct once we get the chemical information required by the Oil and Gas Commission.
Okay, let's please move on. Thank you. That's the last question, and we're going to direct this to Weld County and Boulder County to answer first. Can you provide an overview of your positions of what Longmont cannot impose on a drilling fracking operation?
I think as Mr. Barber has explained, that's a legal question. So it's something that I think we should have the lawyers answer. Thank you.
There are only a couple of what we call in the legal profession reported decisions of the Colorado Court of Appeals or the Colorado Supreme Court. And what is clear from those decisions, and granted that decisions can always be reversed by courts, they do that once in a while, but what's clear from those decisions is that imposing an absolute ban on drilling is not allowable, that most regulation of noise and visual protection is preempted, but then beyond that, there are areas such as fees, such as roadways. I think and this is my opinion, that the regulation of water is probably an open issue in certain respects, especially as it concerns a local issue, and that there's probably more ability for a community, if it can show that it's more of a local issue than a statewide issue of oil and gas exploitation, to regulate activities that relate to oil and gas production.
Thank you.
Yeah, I might just say, if you want to look at the 800 series rules, it's a place to start looking about noise abatement and noise standards that are set by zoning. And so I think the county or the local governments have zoning abilities to you should be exercising. I think the visual impact, and some of these you can just opt out of our rules and create your own rules. So I think there are absolutely places for the county to play an active role. But there are also places where the county has an opportunity to comment, provide meaningful comment, and work with the Oil and Gas Conservation Commission staff to place help work out conditions of approval that can be placed on permits that are site-specific.
Thank you. All right, well, that was our last question. I first want to thank all our speakers and panelists, and I appreciate everybody's time this evening. For the comment cards that the public has, if you can please, you can set them up on the back table, or if you bring them down here, we're going to compile them and ensure all the advisory board members as well as council members receive those comments. And Dale, would you like to?
I would like to just close up a little our presentation tonight and thank on behalf of the city of Longmont. I think it was a good dialogue, and I appreciate all the speakers coming down and helping us with a complicated issue. I did ask that this slide be put up just to, again, remind everybody on sort of the process that we're in and the next steps that we're looking at, and that is to complete the review of the issues and present some of these issues to our various advisory boards, compile those recommendations for both P&Z and City Council. If we have an application brought forward, that we look at the consideration of the potential consolidated drill sites, that, as Brian noted, will go to the Planning and Zoning Commission for their action, that we are looking to prepare and finalize a surface use agreement that will be a boilerplate or typical standard agreement that the city would want to apply on its properties. And ultimately, that decision with regards to consideration of a permit to conduct the seismic surveys on city property. Again, I want to thank our board and commission members to come out. This ran over a little longer than we hoped for, but I hope it was useful. And also, I want to thank the members of the public that came out tonight as well. And again, encourage you to provide those written comments so that we can compile those. So thank you, and everybody have a safe night and drive safely.